I'm Louise Melling, and I'm a Deputy Director of the ACLU, and I just want to thank you all for coming, in particular to come on a Saturday morning at 9 o'clock with gorgeous weather, and for people from the States on a 3-day weekend. So you all rock. I'm hoping that I know we will promise you something worth your while for having come here at this hour. This session is about equal treatment, in particular equal treatment for LGBT people and claims of conscience. And as people in my office know, I always try to have an upbeat attitude. That's one of the ways you can keep doing civil liberties and civil rights work for 22 years, especially in the reproductive rights field. And so when I think about this panel, I think of it in some sense as a good news panel. That's probably not how we experience it every single day, but you only get to the question of claims of conscience, as Maggie said yesterday, if there's some underlying mandate, if you have something, right? So when there was no recognition for LGBT rights, sort of in a legal context, there was no need to have a claim of conscience, right? There was nothing to be exempt from. So the good news is, see? Okay.
See? Yeah.
It's true.
It's good.
It is what we refer to as Plan B. When the other side has lost Plan A, which is keep people from getting rights, Plan B is create the enclave. So in terms of claims of conscience, as I think all of you know, they're just rising up everywhere in the context of LGBT in countries or municipalities where there are advanced rights. So we see claims of businesses, public, what we refer to in the States of public accommodations turning away people, and in particular turning away couples, be that from inns or bakeries or photography shops, but I think inns most common, or reception halls because of objections to marriages between same-sex couples. We see counseling students at public universities here in the States saying that they'll refuse to counsel students or patients who come in who are lesbian or gay because that's opposed to their value system, so they don't want to have to do that. We see in some countries clerks, we see this in the UK and European courts, clerks who refuse to register same-sex marriages and relationships. And so these challenges are arising everywhere, and so as we go forward as advocates and academics, the questions are, how do we manage these? And I think today we'll just talk about different angles of that, both from the advocacy perspective and the academic perspective. So institutions, we heard some of that, we heard a lot of that yesterday, right, in the reproductive rights context. Can institutions have a claim of conscience? Are we going to exempt institutions? And if so, if we're going to exempt them or not exempt them, how do we think of them as having claims of exercise? If we're going to think about institutions, what kinds of institutions? Churches, mosques, temples? For-profit businesses like inns or Hobby Lobby, and in the States, automobile manufacturers, claiming rights of conscience. Religiously affiliated institutions, how do we think of hospitals? How do we think of universities in this context? When you go to individuals, does it matter if the individual is working for the government or the individual is working for a private entity? Does it matter what kind of harms do we care about? What kind of harms are sort of cognizable and might rise up as we think about something, I'll say, outweighing the claim of conscience? Do we weigh harms to dignity? Is that sufficient? Do we only consider harms to health? How are we going to think about that? And that comes up in the context of when we think both about individuals and institutions. Does it matter if the person has another place to go? If the person can be accommodated? You can go to, there's another inn in town that would host your wedding. There's another hospital in town that would serve you. There's another clerk that would serve you. And one of the challenges I put out to you, and as you think about this, which is it's sort of like one of my mantras at the ACLU, for better or for worse, which is, as you think about this question, would you say the same thing, this is true at least in an American context, would you say the same thing about race? If you're going to say, oh, well, there's another business, would you say that about race? Or, oh, it's not really that bad, you could go somewhere else. Would you say that about race in the States? And if not, why not? What's your articulation? And then I think, Noah certainly highlighted this yesterday, which is, I think, some of these claims are certainly coming from a political agenda. And in a sense, I think some of the contraception may be motivated by opposition to the ACA or opposition to something other than contraception. I think that's true in the LGBT context too. But some of it's definitely coming from a place of faith. How do we think about and recognize the harm to faith or recognize people's genuine beliefs? And how do we go about advancing agendas of equal treatment in a way that also is respectful and produces, if possible, the least kind of backlash or social conflict? So, a great panel to discuss these and other questions. You have their bio, so I don't need to spend all of our time doing that. But Karen Monahan is coming to us from the UK as Queen's Counsel. I've never said that before in an introduction. And she has been active.
And a Republican, so there you are, there's a conflict.
Cool.
A Republican in the British sense.
I kind of see that.
Sorry, in the British sense. Anti-monarchy, not pro-Reagan.
Well, that could also
Tea
go.
Party.
And she's been active in many, many of the most important cases in the UK. Simbongile Dinesh comes to us from South Africa. She worked for several years for Interrights. She's been working to advance LGBTI rights through the African Commission on Human and People's Rights. She also worked in South Africa doing women's rights and reproductive rights, and she brings an incredible wealth of experience. Noah Mendelsohn Aviv comes to us as Director of Equality with the Canadian Civil Liberties Association. Larry Sager is an expert in constitutional theory and very well known for many things, but I'll just say today for religious freedom and the Constitution and putting forth some very interesting ideas about the Constitution and religious exemptions. Just brings me back to one question. Should we have exemptions at all? Are we favoring religion in some unconstitutional way when we have these conversations? And Robert Wintemute, who comes to us from King's College in London, where he teaches human rights law, European law, anti-discrimination, and he has litigated and published in the field. So fabulous, fabulous folks. Take it away, Karen.
Okay, I'm just trying to work out.
Oh, and I threatened them 14 minutes, and then I have a stopwatch in my phone.
Okay,
but we're going to be a tad more generous because for whatever reason. Okay.
Okay. I'm going to start by saying something about the regulatory context, the legislative context for resolving claims to LGBT equality, as well as conscience claims by religious individuals and religious organisations in the United Kingdom and across Europe. As I understand it, I wasn't here yesterday, unfortunately, but as I understand it, there was some discussion about this yesterday, but just taking it fairly shortly so I can come to some of the case law, which is illustrative of the different approaches taken domestically in the United Kingdom, as well as in relation to cross-European measures. I'll just look very briefly at them. First of all, the European Convention on Human Rights, which I think was touched upon yesterday, a Council of Europe instrument, the main post-war European human rights instrument, binds all member states of the Council of Europe. It contains an equality clause. That equality clause is operable where any complaint falls within the scope of the substantive rights within the Convention, including, for example, privacy rights. And privacy has been one way in which LGBT claims to equality have been run. The equality clause, Article 14, is open-textured, so it isn't limited to any formalistic concepts of discrimination. It addresses discrimination on a number of enumerated but open-ended grounds. So whilst sexual orientation isn't identified in terms, case law from the European Court makes clear that the Equality Clause will cover claims to equality based on sexual orientation. It also contains a freestanding guarantee protecting the rights to hold a religious belief and to manifest any religious belief subject to particular qualifications. So an interference with the manifestation of a religious belief may be justified, as may be a violation of the Equality Clause, where justification starts and ends has been one of the most controversial areas, as between religious organisations and religious individuals and those seeking equality for sexual minorities. As I think you also heard yesterday, regrettably for practitioners and frustratingly for practitioners, the court often shies away from dealing with controversial issues when there isn't any consensus across Europe about what the right answer might be. I think it was described yesterday as the principle of subsidiarity. It's also described as the margin of appreciation. So where there is a particularly controversial area, the court will sometimes resolve it, not by setting down some firm principle as to how the issues ought to be resolved, but rather by saying the decision made or the act complained of falls within the state's broad margin of appreciation. So wide scope for implementing the Convention rights, those rights protected under the Convention, where the areas concerned are especially controversial. And unsurprisingly, the especially controversial areas are often where the rights of sexual minorities are engaged in the context of those exercising claims of religious beliefs or otherwise purportedly exercising some conscientious objection. So there is, as I say, a frustrating lack of engagement within those issues, purportedly because of a lack of consensus across Europe. And I'll illustrate that in a moment by reference to one particular recent case. Secondly, the next main source of law for domestic practitioners in the United Kingdom emanating from Europe is via the European Union. The European Union, in its foundational treaties and now in its Charter of Fundamental Rights, contains a number of equality guarantees. They vary in content and form. Some of them are more open-textured, covering a wide range of inclusive grounds, expressly now covering sexual orientation, and some are more formalistic, particularly in secondary legislation. Unlike the Convention, the EU rights are generally in the United Kingdom binding as a matter of domestic law. The European Convention is not binding as a matter of domestic law. It's been implemented through the Human Rights Act, but in a particular way, and not upsetting the sovereignty of Parliament. So ultimately, even in the sphere of human rights, under the Convention, parliamentary sovereignty prevails. The legislature can opt out of certain of the Convention rights as a matter of domestic implementation, even if not as a matter of interstate obligation. The next main source, and I think this wasn't addressed yesterday, so I will say something shortly about it, is domestic law, of course, and we have now a consolidated statute addressing discrimination against all the protected classes. They include those holding religious beliefs, and they include discrimination connected with gender reassignment as well as sexual orientation. The Equality Act, as it is, prohibits discrimination, which it defines fairly formalistically across a wide range of prescribed areas, including in the sphere of employment and occupation, including in the provision of services, highly controversial, come back to, and in the exercising of public functions. The concepts of discrimination it adopts, as I say, are fairly formalistic. There is a prohibition on what we describe as direct discrimination, so formal distinctions in treatment, not serving a gay person in a bed and breakfast, for example, as I'll come back to, because they're gay, as well as, for example, facially neutral treatment, which disadvantages one or other protected class. As I say, those rights are enjoyed not just by lesbian and gay and transgendered people, but also by those holding particular religious beliefs. Unlike the Convention jurisprudence, there is no margin of appreciation, and in the case of direct discrimination, formal distinctions in treatment, there's no general defence of justification. So if it is direct discrimination, there is a refusal to serve a gay couple, for example, and it falls within the prescribed circumstances, in the provision of services, for example, it will be unlawful absent a specific exemption. And the exemptions are where the controversy lies, because there are, perhaps unsurprisingly, a large number of exemptions, including in relation to gender and transgenderism, and in relation to sexual orientation and religion and belief. So religious organisations, for example, are given wide opportunity for discriminating against transgendered people and sexual minorities, and including sometimes women. Those exemptions have been worked out by Parliament, by the legislature, so the courts, subject to Convention law and EU law, the courts have been given very little discretion about how they moderate the rights between classes. The battle in the legislature was huge. We have, remember, utterly bizarrely, we have an established church. So we have the bishops, the Anglican bishops, sitting in the second house, in the legislature, campaigning for wide religious-based exemptions. And what we're never allowed to use is the H word, whether or not these beliefs are worthy of protection in a pluralistic liberal democracy because they're homophobic. Instead, we have to defer to the general consensus that these ideas, because they emanate from a belief in from a particular faith rooted in this context, Christian belief, then they are by themselves worthy of protection, and therefore exemptions protecting the expression of them have been introduced into domestic law. The real issue, the real battleground for practitioners and campaigners at the moment is how these diverse laws actually operate in practice, in particular when the schemes adopted are very different. As I say, we have a very clear formal set of laws under the Equality Act, and although the exemptions are enormously controversial, they at least are certain and leave little to the courts to debate or to eat away at the edges of. They have the virtue of certainty, and in an area so controversial, that has very significant benefits, I think. Our first anti-discrimination legislation arose in the context of race, and it adopted the same model. So very clear formalistic concepts of discrimination within particular fields, limited exemptions, and that had a very real impact on social norms and what became acceptable and what became unacceptable. So it has a virtue. But how that fits in with the broader human rights-based obligations under the Convention and so on is still being worked through. And I thought I'd look at that through three recent cases that Rob may well speak about as well, since he's had some involvement in these areas. But first of all, at convention level, the case of Awida, I don't know if this was discussed yesterday, was it touched upon briefly? No? Touched on. Shami touched upon it. Well, Awida was a case in which a British Airways worker, a Christian checkout assistant, wanted to wear a small cross visibly. The uniform requirement at British Airways, which was said to be about commercial branding, prohibited the wearing of any visible items of jewellery, except for, I think, earrings or something of that sort. She insisted on her right to wear this. She fought her case through the domestic courts, arguing that the uniform requirement, though facially neutral, was indirectly discriminatory because it disadvantaged certain religious minorities, though Christianity is by no means a minority religion. It's an established church, but anyway, we have to leave that aside as well. Certain religious minorities, and therefore was unlawful under domestic law. She lost, for various technical reasons due to the attributable to the construction of domestic legislation, and also, I have to say, as I think we were discussing last night, because she was an extraordinarily unpopular claimant, and when it comes to legal strategy, always choose the nicest person to run the case, not the most irritating. But anyway, she lost domestically. She went... Oh, is it? Oh, she was lovely. No, we did like... I was invited to a party. We did love Nadia. We did love Nadia. She brought her case to the European Court. The European Court shifted the approach it had taken in earlier case law. In earlier case law, interestingly, when it was concerned with addressing uniform rules, secularism, and the wearing of the hijab, it shifted its approach and said, well, in this context, really we need to be looking at whether or not this could have been accommodated, whether the interference in the rights, her manifestation of religious belief to wear a cross, could really be justified in circumstances where it might have been accommodated. Now, earlier case law in the European Court had essentially said, if you can change job, get another job if you don't like it. If you want to wear a hijab and they won't let you in school, then bugger off and get another job. That approach was moderated in Ouida, a much more liberal approach, introducing, it's said, although I'm not sure it's gone this far, but it's described sometimes as a reasonable accommodation model, as it might be described in Canada. I'm not sure they went that far, but it certainly made clear that really interferences in the manifestation of religious rights had to be justified by something more than mere commercial branding, for example, or a desire to identify oneself with some brand or another. And she won her case, and in my view, rightly. She should have won domestically, I think, but there you are. She won at Europe. In the same case, because the court heard a series of cases at the same time, in the same set of cases, they heard a case brought by a woman called Lillian Liddell, also a Christian. She was employed as a public sector worker, as a civil registrar. We have now civil partnerships domestically, which are statutorily regulated same-sex partnerships. We haven't yet got same-sex marriage, although I'll come to that briefly in a moment, but instead, again as a concession to the religious lobby, civil partnerships were introduced as a way of regulating same-sex partnerships. Once civil partnerships were introduced, civil registrars, like Ms. Liddell, were required to conduct civil partnerships as well as civil marriage. She objected to carrying out civil partnerships because she said it conflicted with her Christian beliefs, and she ought not to be required to do it. Now, interestingly, I know from gossip on the street, and because I have a friend who was affected by it, she managed to have this accommodated for some time because she kept saying her computer was broken. So a gay couple would arrive at the town hall to have their civil partnership conducted, and at least in relation to one friend that I know of, she said, "I'm terribly sorry, Mr. Bloggs, we shall call him, my computer's broken, but I'll get my colleague to help you." Anyway, eventually it was realised that actually this was more than a computer malfunction, and the case came to a head, and she told her employers that she wasn't willing to conduct civil partnerships. She would continue to conduct marriages, but that conducting civil partnerships was contrary to her Christian beliefs because she didn't believe in the union of same-sex couples, but only marriage and sexual relationships within those confines. She lost as well domestically, with the courts holding that this was a facially neutral requirement that all civil registrars conduct marriages and civil partnerships, and though it adversely impacted on particular protected groups, Christian believers, nevertheless it was justified having regard to the rights of sexual minorities, lesbian and gay men. Their rights were engaged, and it was therefore lawful and justified. She went to the European Court, and happily she lost too there. But she lost, regrettably, on limited grounds. What was argued on behalf of the United Kingdom, and indeed all the interveners, including Liberty, and I think, did ILGA? Yeah, ILGA Europe, with Rob, intervened. What was argued was that the rights of gay and lesbian people were engaged. The fact that a reasonable accommodation, if that's the way we're to characterise it, could be made by simply asking another registrar, and there were other registrars, to conduct the civil partnership wasn't good enough when the public authority concerned properly had an equal opportunities policy which required its employees to treat everybody accessing their services with dignity and respect, irrespective of their protected characteristics, and sending somebody away at the door because they were a woman, because they're black, because they're gay or lesbian, was an affront to their dignity and ought not to be accommodated as a matter of principle. That's essentially what the European Court found, but it concluded the case ultimately having regard to the margin of appreciation that I just described. So what it said was there is no common consensus across Europe about the recognition of same-sex partnerships and the extent to which they should be respected, but a public authority is entitled, on the facts of this case, to secure proper respect for lesbian and gay people, by ensuring that their services are provided in a way which respects the dignity of all their users. So margin of appreciation didn't lay down the principle that same-sex partnerships must be respected, and didn't lay down the principle that the rights of sexual minorities in those circumstances should prevail. So ultimately, as I say, a frustrating outcome. I've got 2 minutes left. Last case, very briefly, so that's the European level. Domestically, we're seeing those issues worked out now. The Supreme Court has yet to decide a case heard this week, in fact, on a similar issue. In this case, bed and breakfast owners in the private sphere but operating commercially, contending that the running of the bed and breakfast is a manifestation of their religion and belief. They offer services to like-minded people. They have a Christian belief, again, in which they believe sex should be within the confines of marriage only, and they seem to think everybody spends their whole life having sex, and so completely fixated on it. I don't know how we managed to get up to work in the morning. But anyway, so they believe it should only happen within the confines of marriage, won't let double beds to gay couples, even those in a civil partnership, because it's not analogous to marriage. They say our Equality Act is not compatible with the Convention because whilst it provides for exemptions, it doesn't do so in the commercial sphere, and so they're relying on the protections afforded by the Convention in relation to the manifestation of religion and belief. As I say, we don't use the H word, so we start these arguments on the assumption that these beliefs are worthy of respect at all, and the issues are therefore resolved, but we wait and see what the outcome will be. And I think that's my time, isn't it?
That's why she's a Queen's Counsel.
Now we'll hear from Simbangale.
So, I was going to just have, is it right?
Yeah.
Okay. So as Louise said, this is supposed to be the good news.
It's all relative.
And so initially I thought, well, it's good to have good news, but what happens when you have good news and very bad news? And this is a context within which this conversation is taking place. So I worked for Interrights, but my focus of work is on LGBT in Africa at a continental level. So you start talking about exemptions when you have one and one and one and one until you're exhausted. And then you say, okay, what are we giving back from what we have taken? And then you start giving all the exemptions. But when the state policies, legislation is in line with the age, who is looking for religious exemptions? Who needs to be exempted from that? So that's the next piece that I'm going to be talking about, because that's the very difficult kind of conversation which makes this conversation about exemption a contextual, because it's the very bad news. And I would try to talk about how this conversation around what's the local, what's the global, what's the universal, and what's the relativism, because that goes into the strategies that people have on how to engage with the issue. So I was going to talk about the good news, which is this, okay, human rights, of course, that equal treatment is about power. And I normally look at this from the first context where I started working as a litigator in the South African context, because you had a constitution that provided for religious freedom, but really closed down on the conversations around exemptions, in the sense that it recognized the practice of religion, but not in the general limitation clause, but in the recognition provision of religion, that these will be recognized to the extent that they are not inconsistent with other rights in the Constitution. So you had the protection of freedom of belief, conscience, and religion, and cultural practices within that context, that, of course, validity and recognition is subject to consistency with other rights in the Constitution, even before you get to the general limitation clause. So which means that the bulldozers were out, and anything that was inconsistent with equality was just going to be flattened out. So it was good to be playing for the winning team for a very long time. That the wins just came on: decriminalization, pensions, immigration, anything you went to court on sexual orientation, because it was the first constitution to have sexual orientation as a ground, you knew you were going to come back with a win. And then the legislative framework came. You had the legislation on Promotion of Equality and Prevention of Unfair Discrimination Act. And what that did was to try and deal and combat discrimination in the various sectors within which and it still gave the same protection. I think sometimes we joke that the wins were so much that the legislature came to a point during the civil unions legislation, which is same-sex marriage by another name, but it is a marriage, and said, let's start giving exemptions now, because we have taken so much that let's start discriminating again, because the only ground, it's not fair. So there came this legislation that said, okay, religious bodies are going to be able to conduct same-sex marriages, but they must apply, so that you don't put the onus of them to refuse to conduct same-sex marriages. And so once we have applied to conduct same-sex marriages, we won't come back and say, can I have an exemption, please? Because this is what you say you want to be able to do. And then in there came this provision that even state officials would be able to raise exemptions, like how? So it is a provision which is there because obviously once you start saying on sexual orientation you can object, can you stand there now and say, look, I'm not into this interracial marriage thing. You should not be getting married here. What is this interfaith? You're saying you're Jewish, you're saying you're Muslim. No, don't. So that sexual orientation was the only ground that was picked up on that you could conscientiously object on and seek an exemption on. But this was 2006 and this is 2003. There hasn't even been an attempt to challenge this in any court. So I think that's what happens when you have the power and you feel you have won, that we're just going to let this go. We have litigated enough and all sorts of things. I mean, there's all sorts of other reasons, but that's the one thing that is clearly discriminatory, and I don't think there's any doubt that if it were to be taken to court, it would remain because of the way in which the constitutional framework has worked. Now, so that's the good news, but like I'm saying, people are exhausted of the good news because the good news is only at a normative and a legislative framework, because what happens in reality is a completely different mess. Compared to the rest of the continent, South Africa has a lot of body count, people who have been killed because they sit on the intersection between sexual orientation or gender identity, race and class. So people are being murdered over the past couple of years. So there are real problems despite the normative and the legislative framework that the conversation now is in other parts where people are still trying to have beginner conversations around decriminalization. It's like, maybe you don't need to decriminalize, you're going to get killed because look at what's happening in South Africa. So, but that's another, kind of conversation. Okay, I'm moving away from this. But that is the power that one has when you have a normative and a legislative framework. You can give concessions and not. But equal treatment for LGBT people when the power is on the other hand, that you are not in a position to begin a conversation about what equal treatment could be. And I think that's the hardest conversation, because in the context of this meeting and other debates that are going on locally and also globally, how do you get, because this meeting, for example, if you were to put it in any other African country, would be acontextual, like, what? You want to exempt who? We should be exempted from homophobia. What do you mean? Can't we opt out on that basis? So you want to have a conversation about equal treatment, but the framing of LGBT as a fundamental right, that the right not to be discriminated against, doesn't open any door. It closes the door in the sense that you have a conversation that says, what is sexual orientation? Sexual orientation is learned behavior. There's all these phrases, gay for pay, the recruitment, and all of other things that goes with it. So it's not an equality issue. So the tension between what is a universal right, a universal human right, and what is happening at a contextual, because when you have lawyers in the room, the most obvious answer for lawyers who go and work in a number of African countries and they find the laws in the penal code that criminalize consensual same-sex sex is, why are you not in court? Why are you not challenging these laws? Why are you not saying this is discriminatory and violates privacy? It's about health. It's about everything. Why is there no Texas versus Lawrence going on here? And this is the key challenge, that Texas versus Lawrence cannot happen in a context where you have lawyers who are saying we are not willing to represent a particular group. When you have law societies that are saying you come here for a disciplinary hearing because you have brought the legal profession into disrepute because this is the group that you want to represent. So that it is not a possibility to even begin that conversations around equal treatment. So what do you do? What becomes the framing that one can use in talking about realizing equal treatment in a context where the gates are so closed? So this win, the good news kind of a thing, is what consequences does it have for the conversations that are going on? So you're listening to the news, you're watching that there's a fight around same-sex marriage, and you are trying to say, no one wants to get married here anymore, because in the 70s nobody was talking about marriage in that way. It was about, we don't even want that, heterosexual institution that is oppressive. But that language, that argument cannot work anymore, because people are saying, you think we're stupid. This is a trajectory. This is where it starts. You say we decriminalize, but we know this is where it ends. Everyone who's decriminalized ends up with a marriage. So economists talk about this as the law of diminishing returns. So this argument worked elsewhere. What is the new argument now to begin the equality conversation? Because all those arguments are quite difficult when they've been used, and people are saying, we have seen how this conversation is taking place. But the most important thing is how at this level, at the global level, because of course these conversations, they are important in the context of Strasbourg and what's going on there and how the religious exemptions are being discussed, or what's going to happen in the American courts. But when at the global level, and I think this is one of the things we need to be talking about, how are we talking to each other about what this means? So when you say sexual rights, or when you say LGBT rights, because we're not having a legal or kind of a human rights conversation anymore. Like, we have been taken out of the courtroom and we're having a political conversation about what can we actually talk about. So we're not litigating. We don't have cases on, outside of South Africa on religious exemption, because we're saying, how do we even get our foot in the door in other domestic courts, in the regional space at the African Commission? And more importantly now, as we're seeing this tension surfacing so much at the United Nations Human Rights Council about what it means, because it's not people from the global south, and mainly Africa, the activists who are going to a Human Rights Council now saying, maybe you're going a little bit too fast for us, because we want equal treatment, but we just don't think. We understand the UN is a space for setting standards and norms around universality, universal human rights standards. So if we get this, whether it's a resolution, whether it's a treaty, or whether it's a special mechanism that deals with sexual rights, this may not mean what the Convention on the Right of People with Disabilities mean. Because when we make advances at a global level on this issue, it's 3 steps backwards at the local levels, as we have seen with the new laws, harsher penalties, creation of new laws. So other people are going forward that they're able to have a good news conversation, but other people are going backwards. Countries that have never criminalized before are criminalizing. Things that have never criminalized before are being criminalized. And here we're having a conversation around exemptions. So of course it's a legitimate conversation to have because that's what you're dealing with at a local level. But what happens when this conversation is moving into a global level? And so it's a question of traveling. What do I have? Okay. So it's a question of traveling about how we contain conversations because what they mean locally have got other connotations at a global level. Not to say that the conversations should not be happening here, but if it's in an international outlook around religious exemptions, who is being exempted and what is that person being exempted from? So, because all of these advances, all of these conversations are happening at a different level. I normally say that I used to be a radical litigator, universalist, until I moved to London to become radicalized in relativism. Because now I am saying there's nothing more important than context, because I would want to write a brief that says equal treatment and send it to a court in a country, but when I know that a conversation has not happened locally, but what am I saying? That equal treatment is subject to progressive realization now? That you do not go to a court and say you cannot discriminate because it's not? So what's universal about human rights in this context? And so what are we saying? Wait for us? Don't go too fast? Listen to us? How do we make this conversation a truly global conversation and a truly universal conversation, taking into account what is happening, everywhere. So, so I was saying I don't have a lot of good news because you can't have good news when you can't be exempting anyone, when the claim is still for exemption from homophobia, from transphobia, and from everything else. So now you can have the conversation. Exemptions.
Good morning, everybody. Thank you for coming out to hear this panel. It's a topic that I'm extremely passionate about. Do I need to move the microphone closer?
Yes.
Trying not to spill water this morning. And particular thanks to Louise for organizing the conference, to the ACLU and Brooklyn Law School for hosting it, and to Susan as well for hosting us here. I'm here from the Canadian Civil Liberties Association, and I think that the Canadian case has something to say, perhaps not to Africa, but we need to continue this conversation in a different way. But certainly for those countries that are looking at exemptions, at religious freedom and equality, and I prefer to think about it as equality and not just equal treatment, because I think the one does hopefully lead to the other. We've had a number of interesting cases, and we've had enormous progression in the last couple of decades. We had the incremental progression that was very deliberately orchestrated towards same-sex marriage, where activists in the area went after things like pensions and other forms of equal rights before they actually went for the big guns and for equal marriage and got it. And since we had same-sex marriage, there's been an enormous turnaround in people's thinking. We're certainly not there yet, but again, and this is what I'm going to show you this morning, we've had enormous changes in the past 10 years around this notion of religious freedom and what does it mean and where is it coming from and to what extent it needs to be accommodated. So there are a few different categories of cases, and I've broken them down because there really have been so many. that deal with conflicts between religious freedom or conscientious freedom and the right to equality. One I want to mention is the Chamberlain case that was at the Supreme Court of Canada in 2002. And this had to do with books that a teacher wanted to bring into his classroom as a supplementary resource. A young kid's classroom, kindergarten and grade 1, all of the books had same-sex parents in them. One dad, two dad, red dad, blue dad, brown dad, blue dad. That was one of the books. Or Ash's Mums was one of the books. And the court found the right things and said that we need to respect principles of tolerance and non-sectarianism in the school board, and not using those principles as their guiding principles, but rather being concerned about the religious feelings of certain parents had overstepped its bounds, and that was not permissible. But the dissenting position is interesting because that's where we were in 2002, and we've come quite a long way, and I'll tell you where we've come to in a bit. The dissenting judges, and there were two of them, essentially said that on the one side you had the rights of homosexual persons to be free from discrimination, and on the other side you had the rights of parents. They never said heterosexual parents, they just assumed that the parents were heterosexual. That on the other side you had the rights of parents to have certain religious and moral views, a right to freedom of religion, and a primary role as the educators of their children. That, to me, in 2013 in Canada, reads like a very problematic statement. We had the Mark Hall case involving a Catholic student in a Catholic school, which in certain provinces in Ontario are not just government funded, they are constitutionally protected because of Canada's particular history, who wanted to take his boyfriend to the prom. It was never fully decided on the merits, but the judge certainly found for Mark Hall and found for his right to equality. And one of the things that I want to do, I'm running through some of the cases because I promised Louise I would, but what I'm interested in is in trying to see whether there are principles here that we can distill from these decisions that are useful in setting up a theoretical framework and considering the questions that Louise posed to us this morning. I think that's exactly what she's looking for as well. But it is important to know what the litigation landscape has looked like in different countries, and so I certainly appreciate hearing about what's happened in other places. The Trinity Western case involved a private Christian university. It was in the news recently because they want to open up a law school. During this time, Trinity Western was trying to have a faculty of education, and they wanted to have the graduates of their faculty of education be accredited by the province as teachers so that they could teach in the public schools. And the College of Teachers said, no, you can't, because students and faculty at your school have to sign a community standards document that prohibits all sorts of behaviors. It prohibits sexual sins, which includes homosexual behavior, and it applies on and off campus. Therefore, we have a real concern that your students are going to discriminate. Some of the interesting findings out of that case, which some of you may be interested to know, the Supreme Court found for the college, for the accreditation of those students as teachers. But a couple of the interesting statements that came out of them, first they said the freedom to hold beliefs is broader than the freedom to act on them. And I think this is important because it goes to the principle that many of us activists are constantly arguing for, which is evidence-based decision-making. You can hold whatever you want in your heart. The evidence we're looking for is evidence of actual discrimination. And that is a somewhat useful way of saying we do respect or accept your right to hold the beliefs that you hold. And the court did find that they needed evidence of actual impact, that the impact in this case that they should have proven if they wanted to not accredit this college as students is that their freedom of religion would have a detrimental effect on the public school student. But in fact, there was evidence that the graduates of the school who used to go afterwards to a different teacher's college had become competent public school teachers, and there was no evidence that they had engaged in discriminatory conduct. In the context of employment, there is one interesting case involving a religious organization that wasn't functioning as a faith group, as a place of worship, but as a social service organization that was providing services to people with developmental disabilities. They were running homes. And this was a case from 2010 in Ontario in which a woman was a support worker at this organization. This was an evangelical Christian organization. This was an evangelical Christian woman who, 4 years into her job, finds herself, the court doesn't say how, that she's interested in having a same-sex relationship and begins living with another woman. Query when exactly that happened, but that's not our business. The analysis that the court goes through, the organization fires her from her job. Sorry, that should have gone without saying. Once she starts living with another woman, and says, as a member of this Christian evangelical community and this mission and this enterprise of serving the needy, you can't do that if you're going against the precepts of our faith. And the court says we need to examine whether this does fall within the exemption of a bona fide occupational qualification. Firstly, we need to look at whether or not the organization is religious. Check, yes it is. We need to know whether the organization is primarily engaged in serving the interests of people identified by their creed and employs only people similarly identified. And here the court interpreted that to mean that their purpose was religious in mission, because clearly here they were serving a broader public, and so the organization passed that bar as well. But then we get to the bona fide occupational qualification question, which I think of as the BFOC question. Is the restriction a reasonably and bona fide qualification because the nature of the employment? If you're going to be cooking for people and helping to clean them and make their lunches, is it in fact a requirement that you not live with another person in your free time? And despite the fact that some of her job did involve hymn singing and reading Bible with members of the house, because the purpose of the house was not to proselytize, I'm not sure I understand that piece of it, it wasn't part of the job, and therefore the dismissal was not allowed. In the area of the provision of services, I want to tell you about the Brocky case from 2001, because that involved a printer. And I think this is a series of cases also that's been starting to happen. To what extent are you part of the enterprise with which you have a disagreement on the basis of faith or on the basis of conscience? This was a printer who had been approached by the Gay and Lesbian Archives to print not their brochures, but their letterhead, their business cards, and their envelopes. And he said, I'm an evangelical Christian. I can't in any way advance your cause. The interesting aspects of this decision from 2001, firstly, is that the court makes a point of noting the Ontario Human Rights Code, which references the United Nations Declaration of Human Rights and the concepts of dignity, equality, and inherent worth. This is going to come up later in some of the important cases. Refers to this case as a conflict of dignities. And if we're talking about distilling principles, this is an interesting thought experiment. Is it more useful to see this case as a conflict of dignities, and does it give them equal worth? And I think, therefore, actually, it's not a useful phrase, but I'd be interested in hearing your thoughts about that. This court also established, not for the first time, that a corporate entity cannot assert a religious right under the Charter. And logically, I think it is utterly and completely incoherent to think that any kind of institutional body could have a religious conscience. The individuals that make it up under freedom of association, yes, but not the entity itself. And of course, but the court did distinguish between materials like posters and brochures that include editorial content and something like letters. They said, and they also said that service of the public in a commercial sphere is at the very periphery of religion. And so again, there was a deep contextual analysis of this case. And then we get to our bed and breakfast case. From 2011, this is Edie in the province of British Columbia, goes as far as the Human Rights Tribunal. Couple calls up, they make a reservation, the owners discover that the couple is same-sex, tells them that the reservation is cancelled. Mr. Edie hangs up the phone. The Human Rights Tribunal goes to the trouble of telling us the impact on the complainant, talks about how offended and shocked they were, talks about their violation, the indignity and humiliation. So I think that we are starting to make the move that we need to make towards saying, would this be any different if it were on the basis of race? We may be mindful and we may be respectful, and I certainly am, of the fact that for some people this is a deeply held religious or conscientious belief, and at the same time the violation to dignity is enormous and one that we cannot tolerate. We had our big same-sex marriage decisions around 2003, 2004, which in some ways culminated with a Supreme Court case in which the court found that, yes, it would be constitutional to declare that marriage is between one man and one woman, and yes, it would be constitutional if religious officials were exempt from having to perform those marriages. It's interesting that the court said that religious officials are exempt from performing marriages, whether religious marriages or civil marriages. As my own incrementalism and my own evolution has occurred in reading through these cases, I'm now thinking that we need to start questioning even that concept. Religious officials who happen to be working at City Hall but also have a clerical collar in their back pocket, can they really be exempt because of it? And that takes us to the final case I want to talk about, which I think is extremely interesting. And that has to do with marriage commissioners. So these are people working on behalf of the state. They're not state officials, they're not state employees, but it is the only way in the province of Saskatchewan by which people could get married in a non-religious ceremony. And what happened here was, after same-sex marriage was recognized and a variety of marriage commissioners quit or challenged these decisions, and one marriage commissioner was taken on a human rights complaint because he refused to perform marriages, the province said, well, what if we pass legislation exempting you? Either exempting those people who are marriage commissioners before we recognize same-sex marriage, that's option A, or that's the grandfathering option, or exempting anybody who has an objection, in both cases on the basis of religious belief. Now, it's interesting that both exemptions, and I think it's important that both exemptions only recognized religious belief and didn't recognize freedom of conscience. Both of those terms appear side by side in the Canadian Charter of Rights and Freedoms. So why not on the basis of conscience? I have a deeply held belief that gay people are icky. Is that not a legitimate claim for me to hold? Do you not have to respect my deeply held fundamental belief? And I think the very fact that we're looking at this only through the lens of religious belief demonstrates how repugnant these proposals are, that we could pass a law allowing people from the outset, without having to make any effort, to say, I have a deeply held belief that same-sex marriage is icky and I don't want anything to do with it. In this decision, ultimately the test is done through the proportionality analysis. At least that's what the majority decisions are doing, and they look at the benefits against the deleterious effects of the decision, and they say, the benefits in terms of freedom of religion and protecting freedom of religion are not as significant as they appear, because this is not a core freedom of religion issue. It's about the ability of people to act on their beliefs in the world at large. It's not about their freedom to hold religious beliefs or to worship as they wish. On the negative side, the deleterious effects, and here they spend some time, firstly, that these exemptions would perpetuate, and I'm quoting, they would perpetuate a brand of discrimination which our national community has only recently begun to successfully overcome. It would be a significant step backward if we were to pass and allow for these exemptions in law. They talk also about the genuinely harmful impact of these exemptions. They quote from the injured feelings of a person who is affected. But they go on to say it's not just the couple who would be affected, not just their friends and family, not even just the LGBTQ community at large, but the public as a whole would be harmed if these exemptions were allowed. Most importantly, says the court, marriage commissioners serve as, and I'm not sure that is the most important, I think what I just said was the most important, but they say most important is that marriage commissioners serve as agents of the province. It would undercut the basic principle that government services must be provided on an impartial and non-discriminatory basis. So I agree that this is the most powerful argument. I just don't think it's the most important. But I think that if we follow that logic carefully, I would argue that a clergy person with a ministerial collar or religious training and ordination in their back pocket who's just looking for a job at City Hall, they too would not be permitted to discriminate if that's the job that they want to take. Maybe they should find a different job. One of the reasons that I wanted to bring up this case as well is because this case is from 2011, so it's not that many years after our same-sex marriage case, the Supreme Court from 2004. The Chamberlain case from 2002 that I was mentioning earlier, here the dissenting judges outflank the majority on the left. They say it's not even freedom of religion. They say the purpose of this legislation is not to accommodate religious belief. The purpose of this legislation is to permit marriage commissioners to refuse to perform same-sex marriage ceremonies when it conflicts with their religious beliefs. The purpose is to discriminate, and how can that be a pressing and substantial objective? They also try to say that it's not really a religious issue because the whole purpose of same-sex marriage, the whole purpose of civil marriage is to be non-religious. So how can this be a religious issue? Here I think the dissent is completely out to lunch because there is still a human being who is occupying that office, and whether that human being doesn't want to work on the Sabbath or wants to wear a little cross around their neck, we still need to recognize that they have their own right to conscience and to freedom of religion, even if ultimately, on balance between the benefits and the deleterious effects, we're not going to let them do so in that job. I want to conclude just with a few other principles that I think come out of my reading and engagement with these texts. First and foremost, the laws in Canada and the evolution of the case law on marriage, on same-sex marriage, on LGBTQ rights, are essentially forcing the public to get over their prejudice, exactly as they did with race. And slowly but surely, the courts are evolving. And I think to a large extent, the public is evolving. But then again, I live in Toronto, in the downtown, and I work at the CCLA, so my immediate surroundings may not be a good sample. But I think we're seeing an evolution in the courts as well. I think we're seeing an evolution in the language that they're using and in their focus on the indignities, on the discrimination, on the impact. And these principles, I'm just going to throw them out in the interest of time. I haven't put them in any particular order. It's fairly clear to me that allowing individuals to have claims of conscience is one thing. Enshrining them in law as an ex ante exemption is anathema. We wouldn't do it with race. We wouldn't do it with gender. I think that we have to recognize the rights of people to associate, and I think that that's where people can get together and do things as a group. If a group of consenting adults, as I was saying yesterday, if a group of consenting adults wants to get together in a faith community and discriminate against each other, I think they should have the freedom to do that. If they want to turn around and do it with other people, then I think we start to have a problem, and I'm not even bringing children into this discussion. But for all that, I think we also do have to recognize that people have a right, and I'm going to conclude with this. People do have a right to freedom of religion, and that for some people, and interestingly, it was the dissenting judge in the marriage commissioner case who said, unwittingly, the words of a witness who was concerned about incurring the righteous judgment of God if they had anything to do with same-sex marriage. I'm not sure that those of us who care about freedom and who care about human rights can dismiss that as unimportant and as insubstantial, even if, on balance, we don't accept that it is more important. We don't recognize that religious belief as true. We simply say, this is something that you hold dear, but on balance, we think it is important that we have equal treatment and equality in our society. Thank you.
I want to begin by thanking all of the people and institutions that sponsored this event and worked very hard to make it the success that it has been, and thank you for including me. I'm going to be relatively blunt and summary, first in the interest of time, and second in the interest of provocation. My theme is going to be one of being deeply skeptical about religious exemptions as a matter of moral and legal principle. And secondly, encouraging all of you, and the ACLU in particular, to fight these exemptions, not just politically, but in the courts. I unsuccessfully tried very hard to keep the ACLU from endorsing the Religious Freedom Restoration Act in 1993. Didn't only endorse it, it carried its banner. And it was a desperate mistake then, and now I think you owe us all to fight it, and fight it really hard. So here are my blunt propositions. First, the fact that a person or group are or is in the grip of a religious command to do or not do something is now not without more a reason to excuse them from the legal responsibilities that other citizens face. Period. If all you have to say is that you are religiously motivated, it is not a moral reason to be treated differently than anyone else, and it is not a constitutional reason. I'm happy to defend these propositions at length, and I have. To the contrary, not only are there no reasons for singling out this particular source of deep commitment. It may be deep and binding, but humans have many deep and binding commitments and judgments. You know, ICI can have very large capital letters. Not only is there no moral reason for a special excuse, there are very powerful reasons not to grant such autonomy excuses. First, as we saw yesterday in the conversation about the delicatessen sending sandwiches to an abortion-connected facility, granting this kind of exemption on any kinds of fair terms is totally consuming of social policy. Religion by its nature, and we celebrate it for that, is capacious and demanding, and it is capable in any individual of eroding all social policy. And you can't say, as you said, no, you can't say that that olive on top of the sandwich isn't the source of a religious commitment, but you can say you certainly don't get any kind of legal excuse because of your particular view. So the first is, this is a very destructive of any sound social policy exemption. Secondly, if you try to respond to that by defining what is or is not religion, you run into not just practical problems, but extremely deep conceptual problems. To define religion is to violate religious liberty, because any orthodoxy, however broad, is a violation of religious liberty. In an article that my co-author and I wrote about never defining religion, we talked about the Monty Python joke, the battlefield joke in World War I. It was so funny, people would die laughing when they heard it. But you couldn't get a soldier to deliver it because he'd read it, and it is just as self-defeating to set out to define religion. It is a violation of the deep conceptual roots of religious liberty to do so. And if instead you try to balance how important is this to this individual, you put the state in this astonishing judgmental position of saying that olive on the sandwich isn't good enough for us. The state can't do that without really undermining its position of equality to religion. And finally, to advantage one group of believers over another group of deeply committed people, whatever the definition of religion is itself deeply unjust. It is a form of inequality. We encountered that most prominently in the United States in terms of military exemptions. The idea that two individuals whose 25-page renditions of their deep moral commitments would be treated differently because one of them had God at the top and the other one said, this is a reflection of my readings and commitments and intellectual exercises. That's intolerable. And the court wouldn't do it. It took statutes and completely misread them, and it took the Justice Harlan to say, you know, this is unconstitutional, and why don't we just acknowledge it? The example, it doesn't have to be such great stakes. The example that comes to my mind, too readily, are the two Mrs. Campbells living across the street from each other in Richmond, Virginia, both of whom want to provide soup and food for the poor, hence the Mrs. Campbells. It's an American reference, I'm sorry. And the notion that one of them is deeply religious and one merely cares about her fellow human beings, that they should be treated different in either direction, that you would either favor the religious Mrs. Campbell or disfavor it, is on its surface unjust. In this country, we tried a constitutional experiment. And for 27 years, the nominal rule stemming from a 1963 decision called Sherbert v. Werner was that religiously motivated persons had a presumptive right to disobey laws, and that only compelling state interest would justify taking away a religiously motivated person's liberty to act. And for 27 years, when that was the nominal doctrine, the Supreme Court could never pull the trigger on the doctrine. There were only two contexts in 30 constitutionally activist years. One, 4 unemployment insurance compensation cases. We're the only country to ever have a major constitutional rule apply only to unemployment insurance. And it was because of very special equality vulnerabilities in unemployment insurance. It was a special domain. And only one other case in 27 years did this doctrine yield fruit for the religiously committed person, and that was Wisconsin versus Yoder, in which the Amish were given the constitutional privilege to withdraw their children from school 2 years early. And everyone who looks at that either thinks it was a kind of wobbly moment in the court's sympathy for the Amish, or more likely, parents have this right, period, that you do not have to attach to this, that their concerns are religiously motivated. And I think most people think Wisconsin versus Yoder was either wrong or probably, given our particular traditions, right, but right is a matter of the right of parents to shape in sensible way the education of their children. In 1990, the Supreme Court looked at this. It was Justice Scalia, and that didn't help. And he basically said everything that I've just said. He said, the unemployment insurance context is special. That case is now confined to that. And Wisconsin versus Yoder, the way he erased that was to say that's a hybrid rights case. And it's a hybrid rights case in the special sense the other right carried the day. And we added the word. And there are lots of hybrid right cases in this country, and they're all free speech cases. And they're all valid free speech or in some other way autonomy cases. Then the world went crazy. I genuinely believe a form of mass hysteria took place. Some academics, including a former colleague of mine, Doug Laycock, and I name him here because he will reappear in this story right now, fed the view that this was the end of religious liberty in the United States. And a nearly unanimous Congress in 1993 adopted the Religious Freedom Restoration Act, which essentially said, once again, religiously motivated persons have a presumptive right to disobey the law. That was invalidated as a matter of federal authority, but it remained a matter of federal authority over the states. It remained a matter of national law over national activities, and it is what the ACLU will confront in the medical mandate cases. There's no constitutional argument that will prevail, but RFRA they will confront their statute. And I want the ACLU not only to make war on that statute, but to say that it's unconstitutional, because it was and is, as a matter of granting a very special favor to religiously motivated people and arguably violative of our Establishment Clause. But the failed experiment of those 27 years is a very good education. Now, it is nevertheless the case that religious minorities enjoy substantial legal and constitutional protection in the United States, in all of your traditions, and that they should. But they should do so under two very different rubrics than the idea that they are presumptively able to act on their religious motivations. The first is religion is entitled to a very strong equality scrutiny on the part of the courts. And minority religious faiths are often at the disadvantage of majorities They are social and political outliers. If they're not the Anglican Church in England and crosses, they really are religious outliers. And so strong equality doctrines and strong equality legislation are extremely important and virtuous. And that's how we now understand Sherbert v. Werner and unemployment insurance compensation. It's how we understand, I think, valid legislative efforts to help minority religious faiths. It is as equalizing their opportunities, not as crediting them with a special exemption. And the second thing, and this is very important and apt to what I think should be thought of as a political strategy in this area now. Secondly, religious minorities are the great beneficiaries of any general liberties that are conferred by the Constitution or statutes. Because they are social outliers, they will always be at the margins of expression and behavior within a society by nature of their, not always, but among them there will be, and any generosities of autonomy and expressive rights accrue to their benefit. And, by the way, the relationship is reciprocal. In the United States, the amount of good law that has been made by agitated religious minorities, most of our strength of our free speech tradition emanates from religious minorities insisting on the right to proselytize, insisting on the right not to pledge allegiance to the flag, pressing behavioral things, and they've done the United States an enormous favor, but so have we them. Okay. Now, that's my predicate. Cropping up all over the United States now, as many of you know, are cases where the question is whether in the face of gay unions, or better yet, gay marriage, a variety of service providers or officials have the right founded in their religious objections to gay relationships, have the right to exempt themselves from public accommodation laws, from their role as registrars, from bed and breakfast. All these cases are cropping up. The case that has been most prominent in the United States and is a poster child for those who want to grant religious exemptions is Elaine Photography, which is apparently a pretty small photography company. I think her name may be Elaine. Oh, different. But, yeah. Anyway, Elaine Photography is a case where the facts are pretty well settled. There's not much factual dispute at all. Elaine Photography refuses to photograph a same-sex commitment ceremony on religious grounds. And Elaine Photography is covered by the New Mexico Public Accommodation Statute. Case goes all the way up to an extremely thoughtful Intermediate Court of Appeals decision to the Supreme Court. The case, it's very interesting because it's very well litigated case on both sides, and so the decisions read like primers on the state of American religious liberty law. Every possible argument was made. Everyone is plausibly rebutted by the court. Up to one interesting point, which is really critical here, they get to what I'm inclined to call the state's little RFRA. And what I mean by little RFRA is that when the Religious Freedom Restoration Act was declared invalid in its application to states, many states took up the idea of legislating their own RFRAs. As it looked like the entire map of the United States was going to be RFRA'd, but only 16 states.
They're working on the others. Yeah.
Well, and what the Mexico Supreme Court said about its RFRA is it does not apply in a litigation between private parties. Well, that can be changed with a stroke of the legislative pen. And the Elaine case is in some ways a rather sympathetic case because I have 5 minutes, but that's okay. So that's why I was blunt. Otherwise, I'd be out of time. The Elaine case looks attractive, a photographer, a kind of an expressive act, a kind of intimacy, a kind of reflection of art, small entity, and so forth. And what is now taking place is a political movement throughout the United States to create a new set of exemptions on behalf of religiously motivated persons confronted with the bed and breakfast confronted with the religious venue confronted with photography. And that fight will largely, but not necessarily exclusively, be fought in legislatures. And the same people, and I told you Doug Laycock would re-enter the story, very sophisticated scholars and advocates are now agitating for a second wave of the Religious Freedom Restoration Act. I'm convinced that the gay marriage will be used to reinstate at the state level much more vigorous forms of restoration. So I have a couple of things to say. One, obviously those political battles are enormously important, and the fact that the Doug Laycocks of the world are reasonable and concerned and equitable and want things reasonable, please, ACLU, this time, understand what kind of door you're opening by almost any form of this legislation. Almost, I want. Secondly, I think the constitutionality of these laws, which in our galaxy are called permissive accommodations, these permissive accommodations have to be looked at hard and have to be attacked. RFRA has only been applied by the Supreme Court in one case. It didn't say a word about its constitutionality. It's a case that could have been decided under the Free Exercise Clause as an equality case. I would have endorsed that as an equality case, o centro. So now is the time to see what vulnerability RFRA and all these laws have, because that we are going to pass through the eye of a pretty scary needle at this point. The second thing is, to the degree, and this is both morally sound and politically strategic, I think. The second thing is, to the extent that it is very appealing cases, like Elaine photography, that are on the table, instead of talking about reasonable accommodations of religious belief, which is just a slightly diminished form of RFRA, what should be talked about are exemptions available to all and available on extremely limited factual circumstances. And what I have in mind, for example, the prototype I have in mind is the exemption that was granted in the Fair Housing Act of about the same time, right? 1990 something, the modern Fair Housing Act granted something called Mrs. Murphy's boarding house exemption. And the idea was, if you have fewer than four or fewer rental units in your own house where you live, you do not have to comply with the Fair Housing Act. The thought was there is a kind of privacy of small numbers and it's your house, and so on. So the question is, if you care that much about photography, if you care that much about corporations that only have 5 people, think about carving them out, but make them liberties for everyone, and make them liberties that could apply in principle to race. The interesting thing about Mrs. Murphy's boarding house is it could apply in principle to race. And so and I believe entirely on insisting on race. And the Doug Laycocks of the world will say race has a special role in American constitutional history. You can't use it as a comparator. You have to. But there are, in principle, you can carve out very small exemptions open to everyone and ones that you can tolerate on racial grounds. They may be very few. But if Elaine gets to not, who would want Elaine photographing your same-sex commitment, for heaven's sakes? If there are such exemptions, they ought to be granted on extremely narrow factual circumstances of a private conduct sort, open to all, and passing Louise's test of we could tolerate this with regard to race. That's a small number. It would be much better than a kind of pale reenactment of RFRA. So that's all I have to say.
Thank you.
I'm going to make a short personal introduction, and then I'm going to do, the middle is the express version of a presentation at the Central European University in Budapest in June. And then I'll have a short conclusion on solidarity between groups facing discrimination. So first, personal introduction. I never really had a wristband that I liked and could wear for more than an hour. But I was in my home city of Calgary, Alberta, Canada, on the 1st of September and happened to run into the LGBT Pride Festival. and picked this one up, and I've been wearing it happily ever since. So I'm wondering if it could be considered a sexual orientation identity symbol. So I'm wearing it around and waiting for discrimination. I want somebody to tell me I can't have a job, I can't be served in a restaurant because of it. And it's just not.
Let's go to Moscow.
It's just not happening. So I'm just going to have to keep trying harder. I know I have all the INCLO member organizations who will support me. I was a few weeks ago in Tallinn in Estonia walking next to large groups of Russian tourists. And I was kind of waving my wristband, seeing if I could provoke an incident, but there's no such propaganda law in Estonia, fortunately. So nothing happened. So I may have to go to Russia and see if I can get arrested there. Right.
There you go.
Sorry?
Come to Kenya and get arrested.
Get. Oh, okay. Thank you. Right. So the other thing I footnote I want to add just about Calgary, because it's sort of relevant, is that Calgary is the first major city in North America to have a Muslim mayor. This happened in the autumn of 2010. Naheed Nenshi was elected. He's expected to be re-elected by a landslide this month. I was in London, sitting on my sofa watching Al Jazeera when I heard this news, and I almost fell off. That Canada's politically most conservative city, the Houston of Canada, had elected a Muslim mayor. So that's, I'd say that's progress for diversity. Okay.
Houston, by the way, has a lesbian mayor who ran neither on her sexual orientation nor her gender, but just on her competence.
Right. So maybe there's an anomaly of energy capitals doing inexplicable things. Right, now the middle. Okay. I'm going to try and watch my time here. Now, my title in Budapest was Religion and Same-Sex Couples, from Leviticus, they shall surely be put to death, to Liddell and McFarlane versus United Kingdom in the European Court of Human Rights, employees refusing to serve them, because that is the historical timeline. Right, so first of all, from Leviticus to Liddell, A, history of legal discrimination against same-sex couples. I'll condense this, but one step that's not well known is that in England and Wales we had the death penalty until 1861 for the offense of buggery or anal intercourse. It was carried out through hanging in England, decapitation in Austria, burning at the stake in France. Not clear what the method was used in Connecticut. I once attended an exhibition at Yale on the pink and the blue, and they referred to executions on New Haven Green. Right, so decriminalization, et cetera, and now we have marriage 2013. So B, have religious organizations supported or resisted these forms? I suppose the point of this section is the long and troubled history of relations between the LGBT community and religious organizations and individuals. So support or resistance? Well, certainly the death penalty was religiously inspired. 1983, when I was an associate at Milbank here in New York, I went to a hearing at New York City Council on the proposed amendment that would add sexual orientation to the anti-discrimination law, and watched a coalition of Protestant, Catholic, and Jewish groups oppose it fervently, and it was voted down. It passed 3 years later. In the UK, from 1998 to today, we have an NGO called the Christian Institute that has opposed every single reform, equality in the criminal law, employment discrimination protection, everything. Okay. So my conclusion from this section is that religious individuals and organizations are gradually losing the debate in, let's say, Western Europe and the Americas. So the reaction, as Louise mentioned at the beginning, is a demand for exceptions for individuals, religious individuals, and religious organizations. Okay, first, exceptions for religious individuals. in the particular context of serving same-sex couples. There are really three levels of protection, or three levels at which an exemption could be sought. At the top, a constitutional exemption. This has just been rejected by the European Court of Human Rights in January in the Liddell and McFarlane case. The next level down is a statutory exemption. This has been rejected by both the House of Commons and the House of Lords in votes in May, June, July, roughly, leading to the enactment of the Marriage Same-Sex Couples Act 2013. And both exemptions were proposed, one for all marriage registrars and one for existing marriage registrars, and both were rejected by the legislature. So the only source of an exemption in England and Wales now is, I would say, local administrative discretion, which at the time of the Liddell litigation, it was claimed that some local governments were accommodating their religiously motivated registrars. And Lillian Liddell's misfortune was to be in Islington, in the heart of progressive London, where there was going to be no discretionary accommodation. So I would argue that this particular form of conscience exemption should not be granted at any level, whether constitutional, statutory, or local discretion. One, they are limitless. Religious individuals are everywhere, at all levels of every private and public organization. I heard a reference to automobile manufacturing. So, yes, once you start granting them, there is no limit. And if you start granting them for sexual orientation, as Louise said, what about race, sex, religion, disability, etc.? Two, are they an example of indirect discrimination based on religion? And I must say I was greatly relieved by Larry's conclusion because I thought I was going to appear extremely conservative in allowing any space for religious exemptions. But I was glad to hear that you support them on an equality basis. So I've got a draft article accommodating religious beliefs, harm, clothing and symbols, and refusals to serve others. It's very simple analysis, basically, that when a Muslim woman wears a headscarf to work, where's the harm? Or a Sikh man wearing a turban, Jewish man wearing a skull cap, etc. But when an employee says, no, I will not serve this particular customer because of their sexual orientation, there is a harm, and that is a reason not to accommodate the belief. So Karen has explained the balancing in the Liddell case, and I fully support that. Now, one argument is made that, well, is there really any harm if the religious individual is replaced and the service is provided by someone else? Okay. The problem with this is, first of all, either it requires an overt refusal, which is offensive. So the scenario I would imagine is marriage registrar windows at Islington Town Hall with a little sign, no same-sex couples at this window. Okay? So no one ever proposes that. So the alternative is secrecy.
Or malfunctioning.
Or malfunctioning computers, yes. We'll do it behind the scenes, and no one will know about it. If you don't know, it doesn't hurt you, right? First of all, the secrecy is hard to maintain because there are lesbian and gay staff in many of these institutions who will know about the accommodation and be offended by it. Sorry?
They're also everywhere.
Also everywhere, that's right. Yeah. So there's a problem with maintaining the secrecy, but I would argue even if the secrecy all works perfectly, there is what I call indirect harm to the same-sex couple in not having access to 100% of the service that's being offered. They can be served when an employee willing to serve them becomes available. So there are effectively two queues, as we say in Britain. Imagine the telephone. answering the call center. Press 1 if you're a different sex couple. Press 2 if you're a same-sex couple. We're sorry, no employee whose conscience permits them to serve you is available at this time. We do value your business. Please stay on the line. So that's where I see the harm. Right now, yesterday I mentioned the analogy between refusing to serve a same-sex couple and exemption from military service or performing an abortion, and so I can skip that part. Just one final point about religious individuals. I just want to make, because Haggai yesterday referred to religious people being in the closet. And he used it in a very particular sense. He was talking about the lack of religious attire in this room. So he asked, does this mean that there are a lot of religious people in this room who are in the closet, afraid to be open about their religion? And I agree entirely with that use of the word closet. But the word closet has been used by a couple of scholars in a completely different way, to which I object. One of them was Andy Koppelman at a symposium at Brooklyn Law School. I don't know if anyone attended it. It was published by the Brooklyn Law Review. And he talked about religious people being driven into the closet if they could not express their beliefs at work. And the case he cited was an employee who wanted to display the offensive quotation from Leviticus in his office cubicle. And he said this was being driven into the closet. And Carl Stitchin at City University London has made a similar point. And I say, wait a minute, no, sorry, you are forgetting what the closet is about. The closet is about not being able to say that you're lesbian or gay in the workplace. It's not about any other kind of expression. Christian employees throughout the United States and Britain are entitled to be openly Christian. What closet is being constructed? We're talking about, as Noah said, acting on your beliefs in the workplace, putting them into effect, and that's a very different thing. I'd say there's no being told you cannot refuse to serve same-sex couples in the workplace as part of your job is no different from being told you cannot proselytize in the workplace, and you're not being driven into the closet. Similarly, sexual activity in the workplace is generally prohibited. And no one would say that anyone's been driven into a closet because that is a restriction on their activities in the workplace. Okay, so that was exemptions for religious individuals, which in most contexts I would oppose, especially if it's trying to override an anti-discrimination law. Exemptions for religious organizations. I spoke at Brigham Young University in 2005 at a conference organized by Lynn Wardle. And I chose a provocative title, which was Same-Sex Marriage, When Will It Reach Utah? Now that was... Yeah. Well, that was meant to be provocative in 2005 when only Massachusetts had same-sex marriage. Now it's just a matter of when it will reach Utah. So to keep up the provocation, I have to modify my title. So this is what I did in Budapest. This is the modified for New York version. Same-sex marriage, when will it reach Salt Lake City's Mormon Temple and New York City's Roman Catholic Cathedral? Okay. The religious organizations have three lines of defense here. One, constitutional prohibition of same-sex marriage does not exist in the European Convention on Human Rights or at the U.S. federal level. A constitutional prohibition at the state level. These exist in Utah and Hungary. These will eventually be struck down. Last line of defense is freedom of religion, Article 9, European Convention, U.S. First Amendment. And here I say, yes, this is an impregnable line of defense. So same-sex couples will only pass through this line with the consent of the religious organization after a long and difficult internal debate about reform. So I suppose my last point, so I can move to my conclusion, is that what I optimistically foresee in a bright but very distant future is the withering away of the need for religious exemptions, at least with regard to sexual orientation, because LGBT religious people around the world are going to come out, talk about their lives, confront their religious organizations, and the internal doctrines will change. Pope Francis is a start. So, but this will not happen in my lifetime, so I should stress that. Yeah. Let's see. Okay. Right. So back to conclusion on solidarity. I think, as the INCLO member organizations well know, you are frequently asked to choose sides on very difficult human rights questions. And also, if you're a member of a group facing discrimination, the question will often arise, should I support another group, which may be a group that is very different from yours, which you do not understand at all. Okay, so these... and actually, I would cite South Africa as a good example of that, because the reason that sexual orientation got in the Constitution was because black South Africans in the African National Congress saw the similarity between discrimination based on race and discrimination based on sexual orientation. So I think this is something we have to constantly think about. So here are two examples I want to cite in closing. The first is that I found that there are some gay men who are very hostile to religious persons, have absolutely no sympathy, basically would love to abolish religion altogether. They have caused us to suffer for years and years. Why should we support their claims? So they have absolutely no sympathy for Muslim women wishing to wear headscarves. Forget about the niqab. And actually, one of these people is in Montreal, a friend of mine who fully supports the proposed Quebec Charter of Quebec Values. And I'm in the midst of an email discussion with him about this. And what I'm going to say to him is, if you want to see support around the world for visible sexual orientation diversity, rainbow wristbands in Russia, I think you should be supporting visible religious diversity in Quebec. And by the way, Charles Taylor, the eminent political theorist, has pointed out this anomaly that the Quebec government would jump to criticize Russia for banning rainbow flags in public, but is in the process of banning religious symbols. Okay? Now, my second example of solidarity is that gay men are told that we should support Israel and vacation in Tel Aviv to enjoy the beaches and the nightlife. In fact, the first same-sex couple to marry in France was offered a free honeymoon in Tel Aviv by the Tel Aviv Tourism Agency. Now, this phenomenon is being described as pinkwashing, and Sarah Schulman at City University of New York is the expert and wrote a piece in the New York Times. Now, the general message to gay men, and many accept this message, is that Israel deserves our support, is a normal democracy, it defends equal rights for women, LGBTs, etc. And it's a major center of one of the world's good religions, Judaism, along with Christianity, as opposed to the bad religion, Islam. But many people around the world, including supporters of Jewish Voice for Peace in the U.S., are starting to question this analysis and questioning Israel's democracy and asking questions, is it a racial democracy? Certainly Desmond Tutu, who's the most famous living graduate of King's College London, has been asking this question for over 10 years, I would say. So how do I conclude? I would say, even if it's just a matter of self-interest for your own group, if we want to see equal rights for women and LGBTs in Muslim-majority countries, we have to be consistent in condemning all forms of racial discrimination wherever they occur. And that is the reason why I think LGBT communities should support Palestinian human rights. And I know that INCLO will be dealing with many different human rights issues, but I hope it will develop a clear position on this one. Thank you.
Thank you, everyone. Thanks to the panel. So once upon a time, we originally thought about having the panelists chat together, but there's just not time for that. We're going to open it up for questions, including from the panelists. Fred, Ava, Nelson.
I wanted to add something to Robert's progression of exemptions, which ended at the Mormon Temple, I guess. And I think my sense of religious conservatives is that, rhetoric aside, that they're not really afraid that they're going to be ordered to perform same-sex marriages. I mean, there are so many ways in the United States that is not possible. But I think what is possible, if not likely, is that states could decide to condition the delegation of authority to solemnize marriages on the willingness of the cleric not to discriminate in performing marriages. I was just wondering what your reaction is to that. What do you think that's likely? Do you think it's a good idea, bad idea? That sort of thing.
I was just at media training the other day, and one person said, "Can we start over? Could you repeat the question?" So I was just winding down from presenting. I missed the question. So.
No, that's all right. The question is, what if a state, which I think is likely, that California, Massachusetts, other states, they're not going to order Mormons to perform same-sex marriages in the temple, but they might say, look, we're not going to delegate the authority to solemnize a marriage to a religious cleric unless that cleric or that cleric's religion agrees to perform marriages without discrimination on the basis of sexual orientation. This isn't I don't think it's a big crisis or would be a big crisis for the Mormon Church because in many countries religious marriage is not available, so you just have a civil marriage and then you have religious solemnization. But it seems to be a very big deal in the United States for a variety of cultural reasons. I was just wondering about your reaction to that.
It's a very good question. I have two reactions, I suppose. One is a legal one, and one is a reaction of political strategy. The legal one is that it's really anomalous that the public function of performing civil marriages is delegated to religious officials. I actually would prefer the system they have in France, Belgium, and the Netherlands, where the two are completely separate. But it is entirely arguable that if a public function is going to be delegated to religious officials, it will only be delegated to religious officials who undertake to marry all couples. So, for example, the United Church of Canada, the largest Protestant denomination, heard recently the Washington Episcopal Cathedral will marry same-sex couples. There are examples in New York, Reform Judaism, etc. So you would actually find a tiny minority, or well, depending on the country, of religious officials who would have the power to perform legal marriages. So, and this issue has come up in the UK. The Roman Catholic Church has been considering whether they have to move out of the legal marriage business because they're afraid of being sued. Now that's where the fear is not well grounded. But so legally, I think there's a strong argument for saying no. You can't do it unless you serve all customers, in effect. But as a matter of political strategy, the heterosexual majority is quite attached in Britain, in Canada, in the U.S. to the one-stop marriage. You get legally married and religiously married in one ceremony. So if the LGBT minority is going to come along and say, no, we're going to take this away from everyone, that's a difficult political position to adopt. So Sibon Gile said, I think that's one I will let go.
Ava?
Thank you. I have two small questions, really.
The first one is, there's something attractive in what Larry has been saying, which is about these intimate situations. And there what I'm wondering is, isn't there also an interest on the other side, on the service user, at such an intimate occasion, the photographies of your wedding, the ceremony of your wedding, etc., to not be dealing with a person that has these strong negative feelings about you. Now, I'm not a member of a sexual minority, but I'm a member of a political minority, and MP for the tiny Green Party. I really wouldn't want my wedding to be conducted by a person of, and we have very vigorous far-right political parties that hate us, that really hate us from the bottom of their heart. So that's just a factor that's not at all being discussed, that there might be a benefit on the other side as well, if you had a choice. And I'm thinking of an idea I heard a colleague in the Netherlands describe once, where in his locality, people getting married were like clients who chose on the website of the municipality the person who would conduct their marriage. And they're not saying things like, I don't do gay marriage, but they say things, I really like a gay marriage. This is the gay official talking. I'm especially fond of gay marriages. And another one say, I'll do poetry at your, I'll read poetry at your thing, like that. Okay, it's a small thing in there, but I think, there's a win-win there as well. Then I have another question to you, Sibon Gile. I heard you saying, with a question mark, am I now saying that equality is a progressive realization thing? And yeah, in my opinion, we're always talking about civil and political rights, economic and social rights, but there's certainly a category that are emancipation rights that is a distinct category in the sense that they have to be won by changing culture, changing a context. And in CEDAW it's recognized in Article 5 that this is the obstacles you face, but in human rights law, we are not quite taking that into account. And I'm really, in my opinion, progressive realization might be a way to take it into account, because it's a way to saying you can't be doing nothing, you can't be using culture as an excuse, but it can be a way of that justifies a certain pace in your change, and principles such as you have to take steps, you have to respect core obligations, can be a way of monitoring that there is progress, that is really progressive realization. Now that's very much an academic perspective. I'm wondering if as an activist you can see a point in that, because isn't the problem really that many governments just don't want to commit to taking any steps? Or do you think it might make it, there might be better chances of realizing something if you sort of make the obligation lighter and of just initial steps and not the full thing?
There has been, because that conversation has not been happening in earnest, and what that would mean, because the conversation is equal rights now. Equality for all. It cannot be delayed. This is the nature of the right. This is what equal treatment is about. So that framing of the conversation makes everyone who's saying, but in this context, if nothing is moving, what would be possible? So what happens is you'd find that there is a department in a government, like the Department of Health, that's saying, okay, in an HIV context, this is what we are going to do. We are going to provide, we are not saying that I have men who have sex with men, because we don't know that. We don't recognize that. But to the extent that they are, this is what we are going to start providing. So we're going to provide access to condoms by people who are HIV positive, ARV treatment. So in a way, you're saying there is a recognition, and there is something that is going in there that is the basic step, that there is a recognition. So sometimes this doesn't open, does not progress to the next. So it's like a room of their own. Here are sick people who need treatment, treat people, and then it closes. So it's not an incremental, it's not a progression to the next level. But what is happening with people who are litigating, for example, it's saying, of course there are these laws, but how do you test, how do you engage with the courts in a way where you start building jurisprudence that will one day take you there? How do you get to decrim in a context where privacy is one of the least understood rights, so you're not going to be able to talk about private life because you have privacy in the context of a fair trial around search and seizure, but not about bodily integrity. So how do you have this conversation when you don't have that? So this is what has been suggested as the step to begin moving these broad-based alliances, working with the women's movement, people working on sexual rights. So you start a conversation around what does consent mean and when does the state comes with consent, because then you're talking with people where states don't want to criminalize marital rape, for example, that here you are saying you should have sex with someone who is not consenting, and here you have people who are consenting and you're saying they shouldn't have sex together. So there are all of these beginning of conversation that there are a lot of people, there's a closing down of political space in a number of ways. And so the question is, why is it that when meetings are being disrupted, whether people are organizing politically, that what you are going to hear about in the news is when an LGBT meeting has been? So, which feeds into this gay exceptionalism kind of a debate. But you're saying if we're talking about association broadly with all the other groups that are impacted by the state draconian measures to close down political space, then we can. So what I'm trying to say is there are these conversations that are taking place, but at a dominant or at a global level, this is what you are saying, that we want it now because this cannot be delayed. And until this conversation is opened up, because anybody who's saying, but we are not moving, we want to say equal treatment now, it's like, you're homophobic.
So I had 4 people in the queue, and we're now at 11:15. Maybe we can do something crazy, which is you can put your questions out, the 4 people. If you could do it really briefly, we can and try to resolve it, or some of them may just have to go upstairs to the coffee. Unless you, I don't know what else to do, because I want people to be able to leave at 2. What? You're sorry, you're not. Sorry. I mean, it's fabulous that there's all this discussion, but I really don't want to cheat the next panel, and people have an expectation to go at 2, including staff. So we just have to.
Okay. So my question falls directly on what Simone was just asking, and I guess I'm interested in the relationship between constitutional law and constitutional politics around these questions. And one thing that hasn't come up in the South African context Simone raised is when we're talking about the conflict between religion and equal treatment. I would think that a major player in the South African context would be the so-called traditional African religions or cultures. And there, I agree with you. I think it's not a question of asking for exemptions. That's not really quite the right framework. It's more that these cultural groups are in control, or historically have been in control of local government, right? So the question is, how can you affect transformation on that level when the litigation is kind of ultimately going to the Constitutional Court, which has been quite helpful and is willing to pronounce equality rights now? I guess my question is, how does that interrelate with sort of local politics that is influenced by kind of more traditional cultural, so-called traditional cultural norms? Is it helpful for the Constitutional Court to be sort of proclaiming these rights? Is that helpful at transformation on the local level? Does it help to move people or is there kind of a reaction against the imposition from above of sort of constitutional norms on a local population? Especially when, as I understand it, the sort of authority or legitimacy of the Constitutional Court is being kind of eroded over time.
So we're going to hear the other 3 questions in the mythic hope there's clustering, and I'll ask people if they can to keep their questions as abbreviated as possible, so there might be time for an answer. So Catherine. Christina.
This is a question to Karen. I'm just deeply disturbed by the Liddell decision, in basically applying the margin of appreciation to this case. And we saw
although she was unsuccessful, so it was a margin of appreciation case in which she was, the state,
right, exactly.
The state enjoyed the margin of appreciation against her.
I understand that. And I think that we saw what happened when the court applied the margin of appreciation in abortion-related cases. And so we were pleased, for example, when the court decided in Vaux versus France that we're going to grant France the margin. It was a case concerning fetal personhood. It was a woman with a wanted pregnancy, and due to medical malpractice, she lost the pregnancy. And she wanted the French law enforcement in her city to prosecute the doctor for murder, and they refused to, saying the murder statute only applies to persons. And so she took the case to the court saying that this is a violation of Article 2 of the Convention. So the court was faced squarely with the question of whether the Convention applies prenatally or not. And the court said, we're going to grant France the margin of appreciation, and we knew that eventually an Irish case would come. And the court would have to, in the case of Ireland, which has a constitutional protection of fetuses, to also basically apply Vaux in the Irish case, and that's what it did in ABC, essentially. So it was actually, at the time, it was a victory like yours is, but in the long run, another case is going to come down the road where actually a state is not, it doesn't have the same position as the UK. And I was just wondering if you're thinking about strategies about how to address that, or
not lose ground is the strategy, I think. I think we discussed this yesterday. Not lose ground. Try and develop a consensus which is in favour of narrowing the margin.
Right.
So we're going to let Susanna's question come out, and then we're going to go, I guess.
I'm just following on this one. I have no sympathy for the margin of appreciation, especially in its maximalistic application, because it somehow brings back 19th century ideas of international law. You need consensus before imposing new obligations of states. So it does thwart international protection of rights. And I have no sympathy for the Liddell result in the end. The practical result is okay, but in effect she's totally right. But my question is, what can the court do? Because when establishing rights in a context of European cultural controversy, should the court look for allies? What kind of allies? If the court tells the Russian that, in effect, you cannot discriminate on the ground of sexual orientation, the court is going to somehow exacerbate anti-European feelings and end up with alienating certain countries, thinking this is no longer the convention we thought we were part of. So,
well, that's happening with the UK.
In the
context of terrorism.
For the voting also.
And
the voting right also.
So is there more you want to say on that? And then Simbangla, you can have the last word in response to Nelson.
Do you want to go first?
Okay. Quickly, I think what we were talking about in the beginning, that when you have power, you have the legal upper hand, the constitutional upper hand, that whatever it is that's not consistent with equality then would have to go. And I think this is what happened because from 1994 and I think the mid-2000s, we had a legislature that was serious with the reform agenda. But legally what had happened with customary law institutions, that they had become very tainted because of their association with apartheid laws. So you were not dealing with customary proper, you were dealing with a collusion between racially discriminatory laws and gender discriminatory laws. And then it was easy for the Constitutional Court not to have to do any balancing exercise because it was like, this has been so ossified. This is not even customary law proper. We don't even know what this thing is. So you delegitimize customary law like that, in that way. So it was easy to have all these inheritance rights, these land rights cases, to be able to go and to say, this is how we are going to uphold women's rights. So that enabled the legislative changes, but also the development of jurisprudence, which is something that we are also trying not to lose ground, even though at that time we didn't have a very organized opposition. So we would go to court, the Constitutional Court will invite the House of Traditional Leaders, and they would not show up. And I think that has been the good thing, even with the religious right, that they choose not to show up.
So Karen has kindly offered to discuss this over coffee, even with the caveat that I'd ask people, now it's your coffee break. Thank you so much to the fabulous panel.
I don't know if you share my impression that even though this has been a jam-packed weekend, it feels like every panel ends before we have time to really fully discuss all the ideas that have been zipping around. So I thought while we're all gathering together and settling down for the last panel, I thought I would take my moderator's privilege to share with Robert something that I was thinking of when you were making your comments, Robert, about Leviticus. So I don't know if you know this, but in the state of Washington, this past fall, there was an initiative, a referendum, in which Washington went for marriage equality. They adopted a same-sex marriage new law. And in the same ballot, they also decriminalized marijuana. And somebody explained to me why those two things obviously go together. And they explained that it goes back to the book of Leviticus, which says, when two men lie together, they should be stoned.
That's a good joke.
Isn't that great? So I thought, yeah, you're all the people who have hung in until the end of the conference, so I thought you deserved the laughter. So, the last panel, as you've seen, we sort of have a different approach to this panel. The three previous panels, what we've done is to take particular issues or conflicts and then try to look at those both globally and locally, sort of across national boundaries. And what we're going to do in this panel is a little bit different because we're picking out two particular countries plus one. And we're going to take a look at the very special problems in a particular country that has particular origins of religious repression or different issues going on. So the three countries that we have for you are Kenya, Ireland, and Russia, which Jay is going to talk about. And our panelists, again, we would be here all day if I tried to read you all of their awards and credentials and publications. But in brief, Monica Karithi is from the Kenya Human Rights Commission, where she's a program officer. And she works in the Equality and Non-Discrimination Program on human rights issues, including women, persons with disabilities, sexual minorities, indigenous and other minorities. Mona, as she's known, not only has a law degree from Catholic University in East Africa and Kenya, but also a master's in international law from the University of Bristol, and she's currently pursuing a Doctor of Laws degree from the University of Pretoria in South Africa, so obviously very well educated as well. And Mona has worked for different organizations before the Kenya Human Rights Commission, including the Gate Kenya Trust, Human Rights Implementation Center, and the Kenya Human Rights Commission, presently, National Commission on Human Rights. So Monica will be speaking first, and after Monica, I'll just take care of the introductions now. We'll be hearing from Mark Kelly. Mark is the director of the Irish Council for Civil Liberties and also consortium leader of the Justitia European Rights Network and founding co-chair of INCLO. So that's one of the reasons we're here, to sort of celebrate the new work of INCLO. In 2013, quite recently, Mark was appointed by the Minister for Justice and Equality as a commissioner of the Irish Human Rights Commission. He's also a member of the board of the Equality Authority, which is pending the creation of the new Irish Human Rights and Equality Commission, of which he is a commissioner delegate. So about to get another hat, yet another. Mark is an international human rights lawyer, and before his present post, he worked as an independent consultant with the firm of the Human Rights Consultants, where his clients included the UN, the European Union, and the Council of Europe. He's lectured, he's published, he's done all sorts of things, but you can read the rest of the bio. So those are our two panelists to talk about Kenya and Ireland, and then our commentator will be Dr. Jay Michelson, who is a leading authority on the U.S. religious exemptions movement. He wrote a 2013 report on behalf of Political Research Associates, which is called Redefining Religious Liberty, the Covert Campaign Against Civil Rights. Jay, until recently, was vice president of the Arcus Foundation, where he coordinated the efforts of 40 U.S. LGBT organizations to fight the anti-gay campaigns in Russia. And that's one reason why, in addition to his comments, Jay is also going to put Russia on the table for us, because we all know they have issues. In addition to J.D. from Yale Law School, Jay also has a PhD in Jewish thought from the Hebrew University of Jerusalem. And I also want to tell you his last book, not his current one. You can read about all his other publications, but I like this title. His last book was called God versus Gay, Religious Case for Equality, and it was not only a Lambda Literary Award finalist, but an Amazon.com bestseller. So how many of us can say that? So welcome to the panel, and Mona, kick us off. Oh, let me just tell you one other thing about format. So each of the panelists is going to get 15 to 20 minutes, timing strictly observed. And then at the end of both Monica's and Mark's presentation, I'd like to give you all a chance to just ask questions, just kind of factual questions to get the basic country situation under control. And then after all three panelists have spoken, then we can have general discussion and whatever comments you want to make.
Good morning, everybody. I'm laughing because when I first came here, I was telling Priscilla that I have a couple of confessions to make. If you'll just indulge me, my first confession is this is going to be a history lesson. Everybody here is talking about very progressive things. I feel like I've gotten into we call it back into the future. I've just been put in a time zone and I'm just, propelled all ahead. So you're talking about things I can't even conceptualize, not because I don't want to, just because we're not there yet. The second one is I had never heard of the word religious exemption till I got here, like in this panel, because once again, it's not something that we even conceptualize as a problem. We've not gotten there yet. And the third one is that I thought my discussion was not going to be relevant, because of all the discussions that are being had here is about religious exemption. Mine is about religious opposition. I mean, it's all the way back, to probably what you guys were dealing in the 18th century, 19th century. That's how back we're going to go in this discussion. And then finally, there's no case law. Everybody's quoting cases. There's a case in this European Court of Human Rights, a case here. There are no cases in my country, like I said, because we have just not gotten there yet. There are no cases, even on the grounds of sexual orientation and gender identity. I'll go into discussions why there are no cases, but I won't be quoting any cases either. So, I think I'll first start with Kenya. I'm hoping all of you have had an opportunity to visit Kenya, or to hear about it, or to read about it, or to have some form of background about Kenya. But I was just laughing when I had Sibo's Sibongile presentation, because she talks about their constitution having had protected, sexual orientation and gender identity, and we always laugh in the rest of Africa saying, South Africa is not Africa, because they're also very progressive and very far ahead. But I'm also happy to hear that Sibo kind of brought it back and talked about context analysis, so that you can understand where we are coming from, why this conversation necessarily, what she was talking about, global dialogue, might not contextually be relevant to us. And in fact, it might be detrimental if you think about it in a very serious conversation. So I wanted to go a little bit into our constitution and the concept of religion in our constitution, and the concept of religion in general in African states, but Kenya. One of the things I also wanted to just put a caveat is I will only talk about Kenya, not because there are no other African countries that have these problems, but because if I don't contextualize, then there's a problem that you might start thinking about Africa as in Kenya being the case example of all of Africa. Every country in Africa is different. Very, very different. For example, in Nigeria, religion, religious oppression is in the form of Christianity fighting with Islam. In my country, we coexist. We are happy. We are happy. So it's. I wanted to just put that caveat there. So I'll kind of go into what religious freedom means in Kenya. And basically, people always say that Kenya is a secular state. No, we're not. Kenya is not a secular state. And if you look at our constitution, this is our new constitution, by the way, but new because it was passed in 2010. So we have a relatively young constitution. And we go throughout our constitution, it's peppered with the fact that, we acknowledge the supremacy of the Almighty God in Kenya. That's the first line of our constitution. And we go on to say how, our national anthem is a prayer. It starts with, "O God of all creation." That's the national anthem. And you move on, and they say there's no state religion. However, in every state meeting, an imam will pray, a Catholic priest will pray, a Protestant will pray, a Presbyterian will pray. This is before a national announcement. All these people will pray. That is how entrenched religion is in my country. And of course, when I was talking to Priscilla and I was telling her that the biggest challenge of our constitution passing was the discussion around abortion, which is one of the things that is being discussed here, and sexual orientation and gender identity. And what happened is, for us to get a new constitution, we had to give those two away. We could not argue sexual orientation and gender identity or its provision in our current constitution. We could not argue for abortion. Otherwise, our constitution would not pass, period. And you know, constitution is passed by a referendum process. And a referendum process means the whole country votes on the constitution. To get our country to vote on the constitution, we had to stop talking about sexual orientation and gender identity. We had to stop talking about abortion. That's how entrenched our people's feelings are on those two issues. That if you put them in a constitution, it just will pass, period. Now, we also enjoy something that I don't think many countries say that they enjoy. We have two systems. We have a regular common law system, obviously, because we were colonized by the British. And then we have an Islamic system where we have Qadhi's courts that actually hold as much power as a regular court, you know, where the provisions of a Qadhi's court will actually apply in any regular court and can be upheld up to the constitutional court, which is the highest court of our land. Now, just to kind of contextualize the discussion about sexual orientation and gender identity, once again, I told you this is going to be a history lesson, so bear with me. Sexual orientation and gender identity actually is not an African. You know, everybody. I just wanted to, all the people here who are always, who are always told that it's a Western import. It's okay. It's not a Western import. Actually, if you look at Kikuyu, Kamba, these are ethnic tribes in my country. Kikuyu, Kamba, Nandi, Kisi. We actually had recognized and accepted forms of same-sex marriage. In the Kisi, a woman can get married to another woman. Same thing as in the Kikuyu tribe and a variety of other tribes. Now, just to expand the context, this goes all the way from the north and to the south, the Khoisan and so on and so forth, and the Fulani in the north. So it's same-sex unions actually existed customarily in our country and in our context and in our traditions. So it's not a Western import. And what happened is, before colonization and before civilization, I start with colonization and civilization, like I said, history lesson, we had traditional religions, and when you brought it up, Nelson, I really laughed because I was like, I'm going to talk about that. So we have traditional religion, and it worked, and it's still respected, and my grandmother still prophesies, under those religious systems, and we were governed by traditional leaders. So when you had a customary marriage, like a woman-to-woman marriage, it was acceptable, and it was recognized even in our laws when we were governed by customary law. Now later we were civilized by the coming of the missionaries. And when they came, they taught us good things, like English, which is what I'm speaking now, yay. And they taught us the Bible. Not so yay, because now when you start talking about the Bible, everyone is quoting Leviticus and all that good stuff, then it permeates through our own traditional religion and values. Because as you're being taught language, as you're being taught English, you're also being taught all these restrictive forms of how you view, or how the colonizers, civilians, the missionaries, let me just call them the missionaries, how the missionaries viewed, that particular relationship between two men and two women or two men. Now then you have colonization. Now colonization brings a very interesting set of difference in Kenya, because what happens is they formalize this teachings. They bring common law as England viewed it. So I remember, is it Robert who mentioned the Buggery Act and all that? All that came, lock, stock, and barrel, and it was put in our laws, and it was acceptable. So what does that do to the people who are being governed by these laws? You have an interplay between traditional values, as we understand them and how I've been raised, and the new concept of Western values. So it's not that Westernization is a bad thing. What it does do is it introduces things that we don't understand. And because it's coming from people who are apparently, and no offense, superior to us, we take it because we think that's the right thing. I mean, that's what civilization is, right? Teaching us what's right and what's wrong. And in fact, when they came in, and currently now, our laws are such that laws are applicable. Customary law, what I know and what I understand, is applicable as long as it's not repugnant to justice and morality. So what is my understanding or definition of justice and morality? It's what you have told me it is. Justice for me is not talking about those two women who live in the village, Manyata, at the corner. But you tell me, well, that's wrong. So I'm like, oh, okay. So that's wrong. And that becomes my new reality. And then what that does with the centralization of governance during colonization, then you have a situation where all these traditions and customs are brought to a head in a central unit of governance. All right. Now, this all sounds like I said a history lesson, but I think it's very important to understand how then it then directly affects me in relation to religious opposition. I can't say that there is religious opposition per se, because in my head, it's not religious opposition. It is what it is. It is the law. It is the system. It is the customary, prevalence. It is what it is. So it's not oppression. The same way yesterday somebody was having an argument about the burqa, and some women think that it's a form of religious oppression, and other people don't. For us, we don't think it's a form of religious oppression. It's just, it is what it is. And I think that's why now when you have the conversations around religious extremism or religious exemptions, then I'm left wondering, okay, so does that mean what I'm thinking is wrong? Because that's a dialogue that's being had in the global north, no? That it's wrong. But for me, it doesn't make any sense, because for me it's right. It makes sense in my head. And I'm so happy that Sibo talked about it. Then you have the larger conversation of the discussions that are had in such an academic space, where the assumption made is that everyone is moving in the right direction, that it's a question of equality now. You see, I was talking to Jay and I was telling him, you see, when you tell me equality now, I get worried. I get very, very worried, because it tells me that if you bring this conversation, in my context, to Kenya, like I said, not Africa, Kenya, when you bring it to Kenya, then I start getting worried that where people didn't think that there was a problem, they will find a problem. What does that lead to? Discrimination, which was never there. I'm happy to live with my best friend is Muslim. She wears a hijab. It's okay. I don't understand why that's a bad thing. But then because this discussion is being had here and you bring it back home, then she starts thinking it's a bad thing. I start thinking it's a bad thing. And then now you have discrimination. Where I tell her, why are you wearing that? Where I never thought it was a bad thing, then I start thinking it's a bad thing. So the dialogues here, once again, now bring out the bigger question of universality versus cultural relativism, where you have a discussion in the global platform about something that if you brought to, like Sibo said, if you brought it to a context of Africa, then it becomes a weapon. It becomes weaponized. It's a fantastic discussion. I'm so impressed about the level of thinking that has gone into this. I feel like, I've learned something new, but at the same time, I'm worried that if you bring this conversation home, you're going to weaponize it. It becomes a form of discrimination where it wasn't originally. And finally, it makes me worried that we are maybe sometimes in this question of universality versus cultural relativism losing the reason why there are human rights in the first place. It's protection of the individual. That is the origin of the discourse, right? Protecting the individual. So if you don't contextualize it in that way, then I start thinking to myself, I might not be maybe as developed in the way that we think about things, but at the same time, if I start thinking the way you think, then I'm in trouble. And not just me, but my society, my people, and just to kind of now take it to the fact that I'm actually a lawyer and I do represent these cases in court, the idea that I don't have to prosecute this kind of issue is a good thing. The idea that because of technicalities such as constitutional protections, which is a very contrary argument, I know, the idea that I can't take it to court and prosecute it to its logical conclusion is a good thing for me, because it means I don't take people, our law is not able to put people in a prison because, the constitutional right to privacy and so on and so forth. If I could have time to go into that argument, it would be better. But I'm happy not to have that discourse. Not because I'm putting my head in the sand. That's not it. Because, everybody thinks, it's coming. This conversation is coming. I know it's coming. I'm aware. I'm very, very aware that this conversation is coming. However, the reality on the ground is if I continue being aware of this, then the reality is the people who are not in jail end up in jail. Then eventually is when now we can have the conversation, then I can remove them from jail. But this is after 15, 20, 30, 40 years, and then we get here, where you can now argue it at the European Court of Human Rights, or maybe in our context, the African Court of Human Rights. But you see, it will take 50 years of my people going to jail before we have this conversation. Am I ready to do that? I don't think so. So am I going to put my head in the sand? Probably. But it's not because I don't want to have it, it's because it's the right thing to do. I'm good, 15 minutes.
Well, you were perfect. Winning awards for both content and timing. Okay, so as I was saying, does anybody have any questions for Mona about the background of Kenya? Anything you'd like to know? We'll have general discussion later, but while you're thinking, while Kenya is fresh in your mind, and Mona is saying she's giving us history, but Justice Ruth Bader Ginsburg recently reminded us, as Shakespeare said, that what's past is prologue. So, Eva, go ahead.
Just briefly about the traditional same-sex marriage, customary. Does it apply to men as well as to women?
No.
Only women.
It only applies to women, and only applies where it is in where the woman is barren and needs to. For us in culture, for you to be able to get a child, then you have to. It's a patriarchal system.
Yeah.
So it's only applicable to women. A woman who's barren and is unable to get her own child, and therefore has to marry another woman who can reproduce, and the children that she gets now become my children because I'm the man, so to speak. Okay. And for the purposes of inheritance. When my partner dies and I need to inherit the property, well, I can't inherit the property because I'm a woman. So I need to marry another woman so that I become the head of the home, not the man rather, but the head of the home. Therefore, I then get to inherit the property. So those are the two contexts in which women-to-women marriage happens.
Any other questions for now, Noah?
Just sort of factual background.
Could you speak into the microphone just so the people sitting in the back can hear?
Are those marriages still recognized, or did that change completely with colonization?
No, those marriages are still recognized to the extent that it's not repugnant to justice and morality.
Any other questions for now about Kenya? Okay, then we're going to move a few miles, and Mark will now turn our attention to Ireland.
Yes, thank you very much. You can see that I've tampered a little bit with the title that you originally gave me, but not that much, because I'm not really going to be talking about religious opposition preventing the realization of basic rights, but I am going to be talking about it impeding it in the past to a more significant extent than is perhaps the case today, but nonetheless still to an important extent. And I was struck by what Mona had to say, because I think we also need to delve back a little bit into the past where Ireland is concerned to understand the moment that we're living through right now. And in particular, I'm going to focus on a period of the last sort of 2.5, 3 years. I'm going to look in particular at a battle with religious opposition around reproductive rights, and in particular our new abortion law. And then I'm going to touch a little bit on future challenges. But first, just a little bit of history and a look back as to how we got where we are now. And I think it's important to bear in mind that until comparatively recently, apologies to those who have their backs to the presentation, until comparatively recently, Ireland was, and I mean the mid-1990s, Ireland was, it was fair to say, a monotheistic, monocultural society, by and large, absolutely dominated by the Catholic Church, and the government dominated by, subservient to the Catholic Church. And that in more recent times that has changed, in particular a series of clerical abuse scandals, demographic shifts, a much younger population, 45% under the age of 35, immigration. A lot of things have changed, but basically we're coming from a place where really the Catholic Church was absolutely dominant. Our Prime Minister, Enda Kenny, who will feature again later in the short story that I want to tell you this morning, in a speech that he made in Parliament last year about the latest in one of our clerical abuse reports, talked about a moment in history in the past when the swish of the soutane, as he put it, which is, as you'll know, is a priestly robe, smothered conscience and humanity. It was a very controversial speech when he said it, but it captured something of that sense of the cassock being feared and the cassock holding sway. But there were nonetheless always people who had counter messages, and this story is also about them. But first of all, let's go back, and the problems that we've encountered more recently really have their origins back in 1982. So this is a period about a decade before things really began to shift in Ireland, when the Catholic Church still held sway, and in particular a very vocal religious right movement decided that it would like to see constitutional change, a constitutional amendment, which, as in Kenya, requires a universal vote to change the constitution in order to put in what they called a pro-life amendment. And this is what we ended up with, Article 43.3 of the Constitution. I'll just give you half a moment to have a look at that. This is what was introduced into our Constitution in 1982. And you'll see that in particular the critical thing is that this is a constitutional provision that gives equal weight, equal significance to, on the one hand, the existence of a fetus, and on the other hand, the life of a living, breathing woman. And so they got what they wanted, basically, back in 1982. Constitutional scholars at the time warned of the potential dangers of this. Rights advocates warned of the hard cases that might emerge on the basis of this. But it was left as it was, and remained the case for basically 10 years. You'll be relieved to see that we're doing about a decade per slide at the moment, so we should be more or less able to stay on track. And then in 1992 we had this case, the X case. Now X is X because at the time she was a 14-year-old girl, which would be reason enough to protect her identity in a court case. But there were a couple of other reasons as well. She had been raped. She had become pregnant as the result of a rape. She had been raped by her neighbour. I can say that because her neighbour was subsequently convicted of the rape. And because she was 14 and had been raped by her neighbour, she began to entertain, and was pregnant, she became suicidal. She began to entertain suicidal thoughts. And she told her mother about that, and her mother told her father, and they said, well, look, there's nothing we can do about it in this country. We'd better go to the UK and look into termination. And they went to the UK, and they were booked into a clinic. And then just before they were due to go to the clinic, the father had a thought. I think he read something in a newspaper about DNA evidence. And he suddenly thought, because the neighbour was denying it, it was the word of this 14-year-old girl against the neighbour was denying, he suddenly had a thought, I wonder if I could get tissue from the aborted fetus and do DNA testing on it, which would prove that it was indeed my neighbour who raped my daughter. It's a dreadful situation, but here at least this may be some redemption that can be got from this situation. So what he did was he phoned the Irish police and he said, look, I've had this idea, I've been reading about DNA, here's the situation, we're just about to go to the clinic, and what should I do? Should I try and sort of get a sample of DNA that I can bring back? And the police said, well, look, let me take your number and all your details and we'll get back to you. What they did was, they didn't sort of phone the forensic science laboratory and say, how would that work out? They phoned the Attorney General and they said, there's an Irish girl just about to have an abortion in the UK. What should we do? And the Attorney General said, well, I know what to do. And he went to the High Court and he said to the judge, can I have an injunction, please? Because this Irish girl is going to have an abortion in the UK. It's not legal here, obviously, if you look back to the amendment in 1982. And the High Court said, yeah, you can have an injunction to injunct her behaviour. Now, exactly how that would have played out in practice, given that they were physically in another jurisdiction, we never actually had to find out, because being highly responsible citizens in this situation, instead of just saying, well, I'm not sure I even want to live in that country anymore, and proceeding as they'd originally planned, they lodged a Supreme Court appeal. And it's quite a good thing that they did lodge a Supreme Court appeal, because when they went to the Supreme Court looked at these facts and circumstances in a more humane way. But of course, they were burdened by this 1982 amendment of our Constitution. And what the Supreme Court said was, in circumstances such as these, if there is a real and immediate threat to the life of a woman who is carrying a fetus, including arising from suicide, which was extremely important, in those circumstances, even having regard to Article 43.3, which I just showed you, it is lawful to carry out a termination. That fits within the existing constitutional disposition. And the judges in the Supreme Court also said, but for the avoidance of doubt, Parliament should legislate. This needs to be written into statute now to make clear that that's what Article 43.3 means, so there isn't a risk, an ongoing risk to the lives of women. Parliament did absolutely nothing about that Supreme Court judgment. They didn't touch it. They didn't go anywhere near it. We zoom forward to 2007. I've only got 2 or 3 cases, don't worry, in the whole thing. When another case went to our High Court, Miss D, and now they conveniently even tell us that Miss D was a minor. She was a 17-year-old girl who was in the care of the state, the care of the health service executive, and she was 4 months pregnant when she discovered that the fetus that she was carrying had a fatal fetal abnormality called ancephaly, which means that it's certain that the brain is not going to fully develop. A significant part of the skull usually is missing or doesn't fully develop. And children with ancephaly, or fetuses with ancephaly, are essentially, if it's in an acute form, as it was in this case, incapable of any prolonged life outside the womb. And so the prospect was that she would be carrying to term a fetus with a fatal fetal abnormality. And lawyers on her behalf went to court and said, this should also fit within Article 43.3. She should be able to have an abortion. And the judge looked at it and he said, well, no, it doesn't actually mean that. But I tell you what, I am prepared to interpret Article 43.3 of the Constitution as including a right to travel, that there's a constitutional right to travel. So what does this mean? What this means now in my country is, or it meant until very recently, does still mean in some circumstances, that there actually is, thanks to this 2007 case, a really clear procedure that you can follow. If you are in Ireland and you're in a situation where you're carrying a fetus and it's other than a situation where there's an acute risk to your life, then there's a really, really clear procedure that you should follow, according to the law, if you want to have a safe and legal termination, and it is that you should get on one of these. And these go backwards and forwards to the United Kingdom on a very regular basis. If you've got a bit more money, then you might want to get on a plane. But of course, the problem is that if you haven't got any money, or if your immigration status is a bit unclear, so you don't particularly want to go checking in with the British border authorities, or if you're too sick to travel, if you literally are too sick to travel for some reason related to your pregnancy perhaps, then tough, you're stuck. This, in my country, is what we call an Irish solution to an Irish problem. If you can't solve it, then why not export it and get the British to deal with it? And it works quite well, actually, in quite a number of circumstances. I'm sorry Shami's not here, actually, anymore to share this with us. So, thankfully, only 3 years later, and the history lesson is nearly over, Europe steps in, and we have the case that Christina referred to earlier there, A, B, and C against Ireland. And in this case, the European Court of Human Rights looked at this situation that I've just described to you in such a potted fashion, and it looked at it in, of course, obviously a much more erudite and detailed way. But essentially it found the situation was as I've described it to you. And in relation to the 3 applicants, they all had different facts and circumstances, which I'm not going to go into, except in relation to Miss C. Miss C was someone who had cancer, and during a period that she was in remission, she unintentionally became pregnant, and then there was a very, very difficult set of medical choices, medical conflicts, because some of the treatment that she should be having for her cancer was counterindicated for people who were pregnant. And it was extremely unclear if she did go ahead with that treatment, what the effect would be on a fetus. Clearly, this was not a set of circumstances that fits within the neat distinction that had been drawn by the Supreme Court in the X case. And so she went to the UK, she had a termination, but with assistance she then took a case to the Strasbourg Court. And what the Strasbourg Court said, and I'm just going to, if you forget, I'm actually going to read this little bit if you don't mind, that the lack of effective and accessible procedures to establish a right to an abortion under Article 43.3 of the Constitution has resulted in what the court said was a striking discordance between the theoretical right to a lawful abortion in Ireland on the grounds of risk to life and the reality of its practical implementation. So in other words, in theory, yes, it's clear, but in practice, no legislation and complete unclarity except for the right to travel. And it said, you as a state must bring clarity to your law in this area. And we thought, in the Irish Council for Civil Liberties, we thought this is a moment. This is a moment for us to seize, to try and move things on, because you'll have this sense of progress by fits and starts. You know, what are we going to do? Shall we wait another 7 years for a Supreme Court case that will be ignored, or looking across the water to the United Kingdom, looking at cases like the prisoner voting case from the European Court of Human Rights, shall we take the risk that our state will just sit on its hands, even in the face of this judgment, this legally binding judgment from the European Court of Human Rights, because it knows how politically unpopular it's going to be, because it knows it's going to stir up a hornet's nest of opposition from the religious right. So we thought, no, we don't want to take that risk. Here is a moment that we can really push. So what we did was we took that concern, that deep concern that this judgment be implemented in Ireland expeditiously, and we funneled it into a process that was alive at the time. We did this over a period of about a year. Ireland was just about to go into its Universal Periodic Review process, the UPR process, first ever cycle of Universal Periodic Review, and the Irish Council for Civil Liberties was coordinating the civil society stakeholder input into that. We just basically took it upon ourselves to do that, and people seemed quite happy, and in the end we had about 107 organisations signed up to this report. The report has a total of 36 recommendations in it on a broad range of topics, as you would expect within UPR, but amongst them was this one, the notorious recommendation number 12, as it subsequently became. And I'll just give you a second to read that. But that basically captures the view of our organisation, but also a view that we put out for limited endorsement by others. The whole report was put out for endorsement by others. You'll see that we are calling also for the governing statute that criminalises abortion in our country to be repealed, a statute from 1861, which, as Robert was pointing out, was the year that the death penalty for buggery was abolished in the country from which the statute emanates. So probably overdue for reform by any standards. The recommendation was included in the report. The report was launched by our Minister of State for Equality. It was actually her first act. We had a change of government, which was also quite promising. She came to launch the report. And on her way out of the launch, she was doorstepped by a journalist. And the journalist only wanted to ask about one of the 36 recommendations, and it was this one. And I was actually at the minister's shoulder as this happened, so I heard the whole exchange. And basically it went along these lines. Minister, has the Cabinet discussed the need to change the law on abortion? And that's what it says in this report. It should change. And the Minister said, well, yes, of course it's discussed it because it's a judgment of the European Court of Human Rights. So, yeah, we've had that discussion. And then she moved on. That was the entire exchange. Next day, in the Irish Times, here is the headline. And this is where we come to the heart, and I have 5 minutes left for you now. This is where we come to the heart of the religious opposition part of this story, because this is when the backlash begins. And up until then, my colleague Stephen O'Hare, who's here with me, was the person who was guiding this UPR process. So I hope he's not going to have too many traumatic flashbacks as I go into this next thing. This is a list which you're not expected to be able to read. Don't worry, it doesn't really matter. But those are the 107 organisations. We've fuzzed out their identities for you, but they're very eminent. The Children's Rights Alliance, Irish Congress of Trade Unions, Irish Penal Reform, 107 serious NGOs. What happened in response to that report in the Irish Times was that a really intense campaign of bullying and intimidation began vis-à-vis these organisations, vis-à-vis people working in them and associated with them. The Irish Council for Civil Liberties didn't get a single call. No one rang us. Nobody. From the religious right. But we began to get dozens and dozens of calls from very concerned staff people, board people in all of these organisations saying, we're being placed under huge pressure. We've had a phone call from a bishop. We've had a phone call from a board member who we didn't even know was that religious, but it turns out that they are. A sustained campaign of bullying and harassment began, and it was ramped up through the Catholic media. This is the Catholic Voice. You'll see the Voice starts at a sort of reasonably moderate level of religious expression. Then, within a few days, you'll see that, I like the inverted commas on this, don't you like those? The Your Rights report is discredited and exposed. And then, by about a week later, because we said to them, well, actually, unfortunately, we've actually already sent that report to the United Nations, so it's too late, you know. We were, at that point, caught in an ugly scandal. Stephen was embroiled in an ugly scandal. We were told that our vile report to the United Nations should be withdrawn. At least they had the courtesy to reproduce the cover, which I think graphically I think is quite nice. And essentially, and I'm drawing to a close now, I promise, this sort of low rumble of opposition continued right throughout the UPR process, and we knew that there were lots of backroom briefings going on with politicians and so on, because there was a real fear on the part of the religious right that legislation was actually going to happen, and they could feel the pressure. We used the UPR process very effectively, and they may even have been gaining some ground until last year, when there really was a tragic development. And some of you may be aware of that, including in this country. Some of you may recognize this person. The woman in the photo is Savita Alapanavar, and that's her husband Praveen with her. In happier times, as we say, Savita was a 31-year-old dentist working in Ireland. She and her husband were Indian and Hindu, and decided to make a life in Ireland, decided they were going to have a child. She became pregnant, and at 17 weeks of pregnancy she was admitted to Galway University Hospital, and she was miscarrying. And it was an inevitable miscarriage. It was obvious that it was from an early stage that it was an inevitable miscarriage. So at 17 weeks, her fetus was not going to be viable. But no termination was carried out because of Article 43.3 of our Constitution, effectively. And what they did, during a period of several days, during which sepsis developed at an advanced rate, anyone who knows much about septicemia will know how dangerous that is, was they monitored her. Well, from time to time they monitored her, but they monitored very intensively the fetal heartbeat. And they kept coming back and checking and saying, is there still a fetal heartbeat? And after a few days of this, Praveen and Savita said to the staff, said to one of the midwives, look, what is going on here? This is tragic, it's terrible, but this fetus isn't going to be a child, a living child, and she was evidently very sick. We want a termination, please. And they were told, no, there's still a fetal heartbeat. And they said, well, but that makes no sense. Why can't we have a termination? And that's what they were told. That's the answer that they got from a midwife in particular. It was denied at the time, but subsequently it emerged that indeed that was true, that was what had been said. And that is, in fact, the truth. And a couple of days later, the termination was carried out because the fetal heartbeat had stopped, but it was too late, and she died of septicemia, tragically, at the age of 31. It made headlines. It was in the New York Times. It was on public radio here in April. So this did have one effect that is notable, which is that there was a spontaneous outpouring of outrage about this in Ireland. And it really was spontaneous. On the day that this story broke, I was walking home, and I've noticed I'm always on my iPhone and gadgets and sort of, this is really... And I was walking back through the city, and all these people just sort of milling around who didn't, I know what protesters look like, in my job. They didn't look like protesters. There were people on their way home, but they were gathering and all walking towards the Parliament. So obviously I went too. And hundreds and hundreds and hundreds of people on their way home spontaneously. There were obviously text messages and people and so on, but it was a huge spontaneous demonstration to say, as you see there, picture taken on an iPhone of crappy hand-drawn posters. People came together to say, no more uncertainty about this, legislate now. And I honestly am going to wrap up very shortly now, just to complete the story.
You're not boring us at all.
Good, I'm pleased to hear it, because I am in the graveyard slot. I'm acutely aware of that. So the next step was to say, on the religious right, they were absolutely panicked by this, because this didn't fit at all with the insidious little sort of backroom lobbying approach which had worked so well in the past and trying to pull strings. There were thousands of Irish people in the streets holding up candles saying, We want safe and legal termination in this country and legal clarity, please. So the next thing they did, and this is another little picture show for you, is they turned on the politicians, very, very viciously on the politicians. This is our Prime Minister, Enda Kenny. And these trucks with this particular message and the threat that Fine Gael is the major political party, the majority party in government at the moment, the threat that no one would ever vote for him again was paraded around on these trucks. They were parked opposite Parliament. They were parked opposite his constituency offices. There were versions of this with the faces of other politicians on. And then, as in the nature of these things, it got worse. We were in the run-up to Christmas, so they thought, wow, we should really have a festive poster. Yes. That went up on lampposts. That went up on lampposts opposite the private homes of ministers and politicians. It went up opposite schools. Children were saying, Mummy, why is the Santa in black and white, and what does this mean? Really, really hard push, and it became clear to us there was so much money coming in. When money like that is coming in, there's one question for us: is there a helping hand across the ocean, or is there indeed more than a helping hand? There were all kinds of clues. Netflix, as you know, have been making waves recently by commissioning original drama. It's watched a lot on both sides of the Atlantic and elsewhere. And I don't know if anyone's a fan of Orange is the New Black is one of the ones that anyone's watching that. This is a scene from episode 12. Fans will know that is Tiffany Penny Stuckey Doggett, I think the character's name is. And you see she's leaving a clinic there. And if you look in particular at this poster here, abortion tears your life apart. There's always a better way. There we are in some fictional town in Tiffany's past. I'm not sure we ever found out exactly where that clinic was, although we know where she ended up. And here we are on the streets of our nation's capital, Dublin, in my case. Also in 2013, and here's exactly the same poster. Apparently in Ireland too, there's always a better answer, even if it means that a woman has to die. Massive, orchestrated, paid for demonstrations. I invite you for a second to compare and contrast the quality of the graphics on the posters, their similarity, the number of people that have them. This demonstration, people were paid, the transport was paid, food was paid. This particular demonstration, and I kid you not, I wish I was joking, they offered a prize of 4 iPads for the most heartwarming photos taken of the day. We rebranded it on Twitter as the Vigil for iPads, which actually caught on and trended for a while in Dublin. Massively expensive websites. This is just one example. You see here again that this is our Prime Minister and his kamikaze mission on abortion. That is just one example of many. The good news is that it didn't work. And the outrage was such that even in the force of this very, very strong opposition, the government did pass the Protection of Life During Pregnancy Act. But of course, our friends have not gone away, and that was them outside. They're quite tired now, by the way, because there was several months ago that this bill was passed. 2 final comments. All of this is important in and of itself, but it's also important because the next battle that we face, which is on same-sex marriage, and I talked to Jay about this a bit already, the appropriation of the language of rights. We had what is correctly called a historic vote on same-sex marriage back in April of this year at our convention on the Constitution. It's a participative democracy exercise with 66 people drawn from the electoral roll on a balanced demographic basis, 33 politicians drawn from Parliament according to their political representation, and an independent chair. It's been commissioned by the government to look at possible needs for constitutional reform in our 75-year-old constitution. It looked at same-sex marriage, or marriage for same-sex couples, properly spoken, and the vote in favour was 79%. And we're now 19 days out from a deadline for the government to respond to that particular recommendation. And what that means is, just as we have learned lessons and bear the scars of the recent abortion battle, so have our friends in the religious right. They are a mutating bacillus, and they have identified a new form using social media to try and increase their reach. So I'm gonna finish with two very short videos. They're each less than 2 minutes, and the first one that you see, and I'm cheating a little bit, but I won't actually be speaking while they're on.
Multitasking.
So, but the first one that you're going to see is by something called the Iona Institute, which isn't an institute. It's one man who's very well paid to do what he does, and you're going to see their video, and then I have 2 words, and then you're going to see another very short video, and then I'm done. So, Lloyd, if you wouldn't mind rolling the first one for me.
When a man and a woman fall in love, they can get married, right? So why can't 2 men or 2 women who love each other get married as well? Isn't it discrimination to stop them?
Except it's not discrimination to treat different situations in different ways.
Everyone in caring dependent relationships deserves legal protection, including gay people.
But the relationship of a man and a woman is unique.
Only a man and a woman can make new life. Only a man and a woman can give a child a mum and a dad.
No 2 men and no 2 women can ever do this. So it makes sense to treat something unique in a unique way. That's not discrimination.
Marriage is a private promise between 2 people, but it has a big public purpose as well.
That purpose is unique and important, to give children the love of their mum and dad in one family.
Of course, not all married couples have children, but every child ever born has a mum and a dad.
Marriage between a man and a woman recognises this basic fact, and that's why marriage is our most important social institution.
It's our way of saying that the differences between men and women matter, that the differences between mothers and fathers matter, and that kids have a right to what they long for, a loving mum and dad.
So let's not change the message of marriage by redefining it. For the sake of our children.
Okay, I can tell you're deeply moved by that. The advantage we have, and I think this is a progressive advantage, is we can look at stuff like that, see it for what it is, but also just think about the number of young, creative, dynamic people whose strengths we can tap into to counter messages like that. These guys are playing catch-up and not very well. So I'm going to finish now, and the last thing that you're going to see is a progressive riposte, effectively a satire on the video that I just showed you. And the good news is it's this one that you're about to see that's gone viral. Thank you.
A man and a woman can fall in love and get married. Who'd stop them?
Because unless they're weirdos, they're about to become mummies and daddies. Hooray!
So wouldn't stopping a man and a man,
or a woman and a woman in love getting married, be discrimination?
Yes, but it's what we call the right kind.
You see, the mammy-daddy relationship is a very special one, having been the only one in all the books up until the 1950s.
Daddy goes out to work while Mammy makes cakes and babies for him.
No 2 men and no 2 women can ever do this. Have you ever seen a gay pastry chef? Of course you haven't. That's what mammies are for.
Are you saying mammies don't make cakes?
Who's discriminating now? If you disagree with us, then you are, you big cake-eating bully. Don't make us set the dogs on you. See Rusty run.
Look, people can do whatever they want, even weirdos, so long as we agree with it. Unless they're women. Women always need to be told what to do, even if the issue is medical.
And what women should do is mainly baking. Come on, ladies. You can always find an oven in a hospital.
Ignore the European Court of Human Rights and the UN. What would they know? Sure, half of them are probably women who've never seen the inside of a cake tin in their lives.
And the top medical experts drawn here agree. Take it from us, they're experts, like those ads about toothpaste where actors are the dentists.
Women should be mammies, and kids have the right to a female mammy in a lady apron, and a daddy who smokes a pipe in a house with a chimney and a fence and no grey areas.
And who are we? Never mind that. We're lovely and right. And we have a dog. He does what we say. Sit, Rusty, sit. For now.
See more at one of hundreds of different websites, all run by us.net.
Proudly sponsored by someone in America who's never met you but knows what's best.
Okay, thank you very much, and I apologize.
Thank you, Mark, for the multimedia presentation. So, any questions for Mark about the situation in Ireland or how to make videos? Questions about Ireland? Go ahead, Noah. Talk into the microphone so the people in the back will be able to hear you.
Just sorry, an extremely boring legal question. The law you got on abortion was not broad.
No, it's highly restrictive. Basically, all that it does is it takes the case law in the X case and it puts it into statute. So it is still the case in Ireland that you can only have a lawful termination if you're in a situation where there is an identifiable risk to your life as a woman. Doesn't cover health, doesn't cover rape, doesn't cover fetal abnormality. So it's a step in the right direction. It's a wedge opening. The next step for us is that we're working with a group of women who have endured fetal abnormalities and have had to suffer the degradation of travelling to the United Kingdom to have terminations, to bring a legal challenge. And the point of the legal challenge will be to take the government up on something which they did in Strasbourg a number of years back. They were challenged in Strasbourg by a woman who was in those circumstances, and the government's legal pleadings in that case, it was called D against Ireland, were that she should have exhausted domestic remedies, and if she had gone to the High Court might well have declared that she could have a lawful termination under the current constitution. So our case is that we're going to go to the High Court and we're going to say, so what do you think about this? And if they say, no, that's completely wrong, then we'll go back to Strasbourg. And if they say, yes, that's right, then we've made another step. So that's a strategic litigation challenge is probably the next thing that we're going to do to try and open that wedge just a little bit further. But it's the first step, that's all.
Okay, one more question from Scylla.
Thanks. Mark, I was wondering, I noticed that there was the little reference to women's medical care in that gay rights ad. That women, doctors, they want to tell women what to do about their medical care, and they show her on the bed. And I was wondering if there was dispute about putting that in, because clearly that's a reference to the abortion stuff.
We didn't make the video. I'm sorry if I didn't want to give you that impression. I wish I had made the video. But the video was made by 2 or 3 people in a design house in Dublin who saw the original and were just outraged, and they thought, well, we're not working this morning, we're going to make that instead.
Right.
So, yeah, but yes, it clearly is.
But they clearly combined the issues, and you're not getting pushback from that. Which it's helping.
They are. In reality, and that really is the subject of our panel and probably the discussion that we're about to enter into now. They're part and parcel of the same issue.
Exactly.
In a country that's moving on, I hope, from being a theocracy to being a country where the rule of law applies on a human rights-based approach. They're part and parcel, and it's the shift in demographic, it's the shift in social attitude that's going to get us there.
Right. In the U.S., people are so scared one to the other, of sullying yourself with the other issue because we're each trying to move forward. So it's great to see them combining.
Okay, thanks. So now Jay is going to take us first to Russia.
So I'm gonna my comments never follow an Irishman, by the way. My comments are going to be a little bit bifurcated. I do have some commentary both on this panel and 2 methodological observations that I wanted to make, but we'll do that after. I'll do the 3rd case study first, and then there'll be some discussion time, and then I'll make that comment. So I just did want to add the third case study to the mix, because I've been involved heavily in the situation in Russia for some time now, in my prior role at the Arcus Foundation, and it's an interesting complication of hearing from the global north and from the global south, and I think what I'll refer to in my later comments as this cognitive dissonance sometimes between the global north and global south, and the global east, so-called, or at least the BRICS countries and Russia in particular, do sometimes problematize that dichotomy in a useful way. So I think probably people know the state of play. Very briefly, I won't give a long history lesson, but homosexuality is officially decriminalized now for over 20 years. Nonetheless, there's been an increasing crackdown just in the last several months, really as a part of a crackdown on civil society. The most famous part of this, or infamous, is known as the anti-propaganda law, which sounds sort of facially neutral, but actually is about any positive message regarding so-called non-traditional sexual relations. So that could be anything from literally holding hands in a public street or wearing a rainbow pride pin, if it could possibly be viewed by somebody under 18. So that's completely shut down, not just sex education, certainly pride marches and anything in a public space, but really even any writing, positive writing. Even if you were, and this is a crucial point, if you were a same-sex couple and you had a child, saying anything to your own child is illegal under the anti-propaganda law. Along with the crackdown, legally has been an increase in semi-legitimated and certainly not prosecuted violence. We've probably seen some of the YouTubes. But it's not just the nationalist fringe thugs who are beating up gay kids and torturing them. Vitaly Milonov, one of the sponsors of the anti-propaganda law, himself was at an LGBT event in St. Petersburg shouting outrageous homophobic, not just epithets, but he was part of the mob, basically at that event. The next horizon legally is a bill that's just been introduced to take children away from same-sex couples, no matter how long the children have been with those same-sex couples, including from birth. Even if it's a lesbian couple and one of the two is the birth mother, the child could still be taken away under the pending law, which has not yet passed the Duma. Almost certainly there will be very few prosecutions and very little action between now and the Sochi Olympics. There's already been a statement that Sochi itself is now a kind of closed military area that you can't enter without a special Sochi passport in addition to everything else. It is contraband to bring a rainbow flag or a rainbow shirt or a rainbow anything to Sochi. I don't know what happens if it rains and there's a rainbow in the sky. And it's almost certain that the Russian local authorities have been in the vanguard of prosecuting and persecuting, will be kind of kept on a short leash between now and the Olympics. So the real question is what happens after February and March. And that's where a lot of advocates are spending their time. I want to draw out kind of three bits of analysis of how we got to this state of play that I've just described that aren't necessarily as well known. This is not really an anti-gay crusade that a bunch of Russians or Putin woke up yesterday and decided that they hated queer people. Actually, this is due to nativism and nationalism, the destruction of civil society, and the influence of the Russian Orthodox Church. First, it's quite interesting, if that's the right word, that a disproportionate number of the youths who are targeted in these hate videos, which are available on the Russian equivalent of Facebook, were either actually, quote-unquote, foreigners or perceived to be foreigners. So one of the most infamous, where we still don't really know what happened, whether the young man actually did kill himself or not right after what was dramatized. They were torturing him for being Uzbek as well as for being gay. This is sort of part of a far right-wing racist, nativist nationalism that's been around for quite some time in Russia and has equivalents probably everywhere, certainly here in the United States, but has received increasing sanction and permission from the Russian authorities. So the construction of LGBT as foreign, which we see throughout, particularly in the global south, but also in Russia, the notion that sexual orientation is a Western vice or a Western import, despite the fact that Tchaikovsky was gay. I don't know if people noticed the irony at the Met, where the Met said they were proudly staging the work by Tchaikovsky, the gay composer, whose gayness is being denied but then Putin also did a pivot and said, no, Russia loves gay people, look at Tchaikovsky. Second, the context of the crackdown on LGBT people is the destruction of civil society as a whole. So the crackdown on the NGO law, the foreign agents law, restrictions on free speech, the destruction of civil society and non-governmental organizations in general. That's made it extremely hard to actually support the nascent LGBT movement in Russia, but that it's part of an overall crackdown. And this we should sort of understand just in terms of domestic politics, that in the first Putin regime he really governed mostly from the center. He's kind of a centrist rightist figure, but in the latest Putin regime he's really governed from the right, far right. If you imagine in our current American context, United States context, if the Tea Party really had the White House. You can argue about whether the Christian right had the White House under the previous president, but if you really imagine someone who was catering to the far right wing, but an even farther right wing, that actually said what it believed rather than didn't, as the Tea Party sometimes doesn't. That's actually the political reality. And this has led to a marriage of mutual enrichment between the Russian Orthodox Church and the current regime, which previously had no love lost. Actually, most of the rapprochement between the church and the regime happened under Medvedev, actually, and there was kind of a retrenchment into Russian culture. The church is consolidating its financial holdings around the country, gaining a kind of semi-official status, and in return it provides the moral legitimacy to the nationalist government in Russia. I'll actually direct you. There's a fascinating law review article by Robert Blitt called Russia's Orthodox Foreign Policy. I won't talk much about the foreign policy elements, but actually kind of traces document by document and working group by working group the connections between the Russian Orthodox Church and Russia's foreign policy, which is quite remarkable. One quotation from that article, there was a statement put out by the Medvedev government and the Russian Orthodox Church to fight any, quote, perceived threat posed by religious and other organizations intending to disrupt Russian unity and territorial integrity and destabilize the political and social status quo. Right, that's a pretty broad. So that actually captures a lot of folks who don't care much for each other, right? So that, particularly on the territorial integrity, that's clearly aimed at Muslims, at separatists, whether in Chechnya or elsewhere, and at so-called breakaway republics and wannabe breakaway republics. It's also aimed at the United States. It's also aimed actually at, the irony here is that the American evangelicals who have been playing an instrumental role, at least claiming to play an instrumental role in the passage of the anti-propaganda law, were in fact the targets of this earlier statement by the Russian Orthodox Church, which resents the incursions of the American evangelicals into Russia. If you've been to a Russian Orthodox Church service, it's a little less energizing than your typical evangelical service. And just as there have been evangelical inroads in Brazil, for example, likewise there have been in Russia as well. That particular policy has been used to target some minority religious groups, Scientology, whether it's a religious group or not, Jehovah's Witnesses, also Western human rights discourse, and the notion of spiritual security, which is kind of a fascinating term, has actually impacted domestic and foreign policy. Whether it's and all of the times when Russian culture is being used in these contexts, it's identified with the Russian Orthodox Church. So there were recently actually in the Vatican. It's nice that LGBT people. I lived in Jerusalem for 3 years, and we brought together Christian, Jewish, and Muslim clerics to denounce the Jerusalem Pride Parade that Haggai organized. Here, there's actually been a celebration of Russian spiritual culture in Vatican City, that the ancient rifts are being healed in opposition to Westernization. Most of us may not actually see the incitement that's going on in a sort of linear fashion, because it's kind of a hegemonic incitement. It's a permissiveness and a permission to these groups to execute the necessary consequences of the legal policy. That's kind of one of the main goals. It's possible that in fact the Russian Orthodox Church is just a more overt version of the hegemonic violence and incitement that we see all the time in many countries around the world. It is unusual to actually have clerics in black robes urging on a mob to beat up LGBT protesters, as happened in Russia recently. But it is, and I'll come back to this in my comments, my overall comments, it's the same rhetoric of defense rather than offense. right? The same notion that we are defending an embattled culture, or we're defending our spiritual security while sanctioning and urging the beating up of these individuals and these people. I've actually shied away because of my own kind of work in the Jewish community from the comparisons that some have made between the situation in Russia now and the situation in Hitler's Germany in the 1930s. But there is one point of connection, which is actually that defensive rhetoric used to justify violent actions against a minority. And it's important, I think, to note that. A second piece that I want to know, there are three kind of these analytical frames I want to say something about, and then I'll finish. The second piece is that the laws as construed are deliberately vague. This allows for a wide deviation of implementation and enforcement by courts. It also creates a climate of terror and fear. So I met with 4 Russian LGBT activists about a month ago, and was talking with them with a lot of other folks about the net effect on the ground. And chilling effect doesn't quite get it, right? I mean, obviously there has been a chilling effect, but it's been a freeze, right, on any kind of quote-unquote propaganda. And it's unlikely, in fact, there's no clarity in the law around what counts and what doesn't. Interestingly, the prosecutions have been very limited, and actually against Westerners more than Russians, which obviously plays into the whole notion of homosexuality as a Western import. But the vagueness in statutory construction is not a mistake, but rather a deliberate idea to create the terror and to create the ambiguity. And that's actually worked. There are a number of LGBT organizations that have practically gone underground. There are others and there's a wide diversity of opinion on the ground as to exactly what this means. Interestingly, there are, and this is just kind of a footnote, there are supportive Russian Orthodox and Eastern Orthodox clergy that are bucking the trend and meeting in secret. There was a conference of Eastern and Russian Orthodox LGBT people that took place in Kiev just about 2 months ago, and these folks are on the ground. However, the Russian LGBT movement and civil society organizations are overwhelmingly secular, and so this is sometimes framed as a religious versus Western or versus humanistic or versus secular debate or conflict. Finally, and this brings me back a little bit to Abdullahi's presentation earlier yesterday, there's an export of what I call negative human rights discourse from Russia to the United Nations and other international bodies. Russia is seeking to position itself as the leader of the Traditional Values Coalition, and ironically, in a number of ironies of imperialism and masquerading as anti-imperialism, is leading a coalition largely of Global South countries pursuing the inclusion of quote-unquote traditional values in international human rights mechanisms with some degree of success. Traditional values obviously are the right to discriminate against other people who don't share your view of gender and sexuality. This is one reason I think we want to be aware, and as the Russian issue bubbles up, I think, in American consciousness to some degree, some have called attention to the fact that there are situations in many countries, particularly African countries, that are much worse than the situation in Russia. And is this essentially, not to mince words, is this because these are white faces that are being victimized that suddenly the West seems to care so much? And I think that's something that we as academics and activists want to be really mindful of, that we not pretend that this is a situation where Russia is some sort of huge anomaly, and that other human rights abuses elsewhere are not deeply problematic. At the same time, there are some distinctions which make Russia particularly problematic from an international perspective, Russia's leadership in international fora being, I think, the chief one of them. It is the case that Russia is using this as yet another of the many geopolitical issues in which it's involved as an attempt to gain stature and to cement its role as an international leader, or create its role as an international leader, recreate. So there are a number of reasons why we want to take a very a nuanced and sensitive approach to the situation in Russia, not claiming that this is somehow unique or distinct from a number of other places around the globe, while at the same time recognizing the uniquely destructive power that Russia is playing on the international front. And I'll refer you to Blitz's article to talk more about how the Russian Orthodox Church is actually guiding a lot of the rhetoric that's used in the traditional values movement.
Questions for Jay about Russia?
No, I just wanted to
Go ahead, Susanna, go ahead.
Sorry, yes. what you were saying now, what I think makes Russia a special case is also the fact that Russia was able, the Orthodox Church in Russia was able to establish this new alliance with the Vatican, other Eastern European states, and American evangelicals, and they have very good litigation strategies.
Mm-hmm.
So what they're trying to do is to undermine the European Court of Human Rights somehow system of protection from within. And that makes me very worried because they've already been very successful.
Yeah, that's absolutely the case. And one of the small victories that we've seen in this area have been on what we were thinking about it as a domino effect in other countries. Armenia did withdraw its version of the anti-propaganda law. Ukraine is still considering its, but has been under severe pressure from Europe not to pass that, and it's still up in the air a bit. But pressure from Europe has had a significant impact in Ukraine, where it did not have any impact, of course, in Russia, which doesn't have the same ambitions.
Any other questions? Any other questions for Jay about Russia in particular? Jay was calling it a case study. We have 3 country studies in addition to a number of case studies.
I can do that then. Yeah, you want me to, so I'll just finish up.
So Jay is going to go on with his commentary now.
Great. Okay. So I just want to make 2 general points and then open these up for discussion. And it's fun getting to go next to last or something because I get to offer some kind of a reflection. The first has to do with, I think, the cognitive dissonance between countries that are on different parts of the spectrum in terms of where attitudes and legal regimes are regarding sexual and gender minorities. And the question I wanted to kind of throw out would be, what are the conditions needed to get from a situation of religious oppression, as Mona, I think, helpfully called it, to religionists complaining of persecution and trying to get religious exemptions? What are the conditions to get from point A to point B? I do want to problematize the linearity that's necessarily a clear linear progression. First, we've seen already the export of religious liberty victimization rhetoric to Africa in particular. I'm sure folks are familiar with the situation in Uganda. The film God Loves Uganda just opened yesterday in commercial release, so you can actually see it, with Scott Lively and with others from America, going and exporting what you might consider to be a late-stage reaction, someone called it the fallback option, religious exemptions, exporting that rhetoric to a place where it's completely inappropriate, right? Where we're still in a place of religious oppression. So it's not linear that first we're at stage 1 and then we're at stage 5, and only at stage 5 do the religionists begin complaining about religious liberty and religious exemptions. Actually, that rhetoric of victimization has been already exported to places which are still at so-called stage 1. Second, I think it's interesting to note from the example in Ireland the shifting of tactics that happens very, very quickly. Just as the U.S. LGBT movement adopted different rhetorics of family and love and so forth from the move from the 1990s to the 2000s, likewise we're seeing the shifting and adopting of different rhetorics across the globe, including in places, again, which may be at different points. I did want to respond to the notion of equal rights now and equality now, and does that endanger people on the ground because of backlash reasons? Having just come out of the advocacy space very recently, I don't think anyone actually says equality now, and meaning that for everyone. ILGA puts out, the International LGBT Organization, puts out a really good map, coding from red to green with lots of shades of pink and yellow of where different regimes are in terms of treatment of sexual and gender minorities. There's clearly a scale, safety to decriminalization to health, access to health. There's a lot of gray area space, but I do think it's incredibly important to highlight the global South, global North legacy of colonialism that's in play in all of the conversations where we try to bring an international look. What's challenging from an advocacy point of view is that the other side has no such compunctions. So we have seen this wonderful irony of homosexuality being described as un-African when actually it's homophobia. And I direct you, there are 2 books, one called African Intimacies and the other called Heterosexual Africa with a question mark, that go into a lot of detail. Mona went into some today on that history. And this great irony that it's not just in the past that homophobia was the colonialist Western import, but even in the present. The notion that homosexuality is an imperialist Western import is an imperialist Western import. So we ourselves, in the more progressive space, angels, fools rush in where angels fear to tread. So the question is whether we, in the name of being angels, are mindful of the fact that the other side doesn't have any of those necessarily compunctions. The way that the religious liberty discourse has been co-opted by conservative voices in similar ways to how feminist discourse has been co-opted by those on the burqa ban struck me earlier in the conference, where we're doing a sort of a head spin, where notions of religious liberty, which used to be those progressive notions, are now being used as a sword rather than a shield. That's obviously true in the United States, but it's also true in some of these exports. So just that little bit of a comment on the cognitive dissonance and the themes that emerge when we're combining global North and global South conversations into one. That there's a lot of interpenetration, a lot of complexity there. Last point. I think the second complication in our conversation has actually been on the limitations of civil discourse itself. Right? No libertarian wants the state, or civil liberties activist wants the state to get involved into adjudicating religious values. But in fact, that may be the zone in which a lot of the progress can actually be made, going back to that question of moving the needle. There's an internal religious incoherence, for example, in supporting the ban on supporting or opposing the contraception mandate in the Affordable Care Act. Are you really morally responsible for providing an insurance option that someone may or may not use? As I understand it, that's not a civil liberties type of question. That's an intra-religious question. That's a question of morality. Am I culpable, morally culpable, when I provide an insurance plan? And doesn't that actually, parenthetically and not coincidentally, remove moral agency and moral responsibility from the woman, not coincidentally the woman, who's choosing to exercise this particular form of health care? Right? I, the presumptively, putatively male employer, actually have all of the responsibilities for all of the choices that my female employees make. That, however, is, I think, an intra-religious argument. And I think there is I did want to push back a little bit, Rob, on your comments about will the change in religion ever happen in your lifetime? The data is there are far more progressive religionists, certainly in the United States, than are represented in media reports and that are represented, I think, even in our own public discourse. These voices are not given space or legitimacy, despite the fact that large pluralities or even majorities often support the sort of more liberal agenda. Catholic support for same-sex marriage is higher than the national average. Incidentally, support in communities of color for same-sex marriage is also higher than the national average, despite the myths often propagated by, not to put too fine a line on it, racist LGBT activists who say that, oh, well, why can't these communities or that communities get with the program? Those statements not only are incredibly offensive, they're also counterfactual. So the reaction to the Pope's statement, for example, has been surprising in some quarters, but it really shouldn't be. There's actually, I think, a larger problem here, which is the dichotomization between secular rights liberals and religious conservatives. One example for a different way forward might be to look at North Carolina with Moral Mondays, where there's been an authentic alliance between folks who are in progressive religious organizations taking in, not quite at first, but eventually LGBT concerns into an overall progressive agenda. More actively than, frankly, the mainstream gay movement has been willing to take on real social and economic issues into its agenda. So it's difficult to complain about progressive or other religious organizations not being gay positive enough when the gay movement isn't necessarily immigration positive enough or real social justice positive enough or economic justice positive enough. I think we do run the risk in that dichotomization of not just a global north centrism, as I think was really helpful from Mona's presentation, the way in which religion is seen, but also domestically, where in many communities of color, the church is seen as an agent of liberation and an agent of social justice. And I think we're at our peril to set up a dichotomy where religion is only the bad guys. And I think that's a very privileged discourse. It's a particularly racialized discourse, and one which I'm sure none of us wants to perpetuate.
Well, thank you, Jay. So what I'd like to do is first I would like to give our panelists, Mona and Mark, the first opportunity to respond to the many challenges that Jay is throwing out there. But first, while you're thinking about what you might want to say, let me regroup some of Jay's comments, because I think it's very appropriate in the last panel going into Scylla's comments that we're pulling back the camera and we're kind of going meta here. So I think Jay has raised challenges in both our advocacy area and our academic area. And as advocates, all are part of us, he's challenging us to think about strategies, adapting tactics, what works. And I think of this as sort of the arc of justice front. Right? Are we moving in the right direction? How do we change how we're moving? And what are the mistakes and wrong assumptions we're making that are getting in our way? So a lot of strategic questions. If we're coming from an advocacy point of view of how do you get there? Is it a mistake to cast the church as being on the other side, et cetera? So there are all those strategic questions. The second kind of question that Jay is posing is one that I think has been with us all weekend, which is the whole question about the universality of our discussion. So, here we are all together from around the world, and we've been trying to have a discussion that's going to cross national boundaries and look at common problems. And again, we also keep finding out more and more about the differences among us. So everybody agrees, of course, that context matters. But I think we've also been struggling with the question of, to what extent are answers here or values or anything else universal? And to what extent are we, as Mona said, looking at a situation of cultural relativism? Now, as Jay was saying, going back to Abdullahi's keynote remarks yesterday morning, one challenge that I find fascinating, which Jay is picking up on, is the whole question of whether the claims of universality of these discussions is itself a form of kind of legal imperialism, if not cultural imperialism. And I think Mark is also raising in Ireland whether we're no longer maybe physically exporting missionaries, but we're exporting missionary dollars. As well as missionary universal ideas. So that's the second question. One is the overall advocacy and strategy. How do you get from here to wherever you want to get? The second is the universality of our discussion in terms of the commonality of these issues across national boundaries. The third meta question that I'd also like to introduce, because it's something that I guess several people have talked about, especially Mark and Robert today, is the commonality of the particular issues we've been talking about. So I think a number of people have stressed, and I think you were beginning to get at this, Mark, the commonality of the reproductive freedom issues and the LGBT issues, and how there's ways in which we should think about those issues as a group, about equality. That's a theme that we've been talking about. But also, more challenging is the commonality of the issue we started with in the first problem, the expression of religion in a public space. And Robert wanted to say a lot in common with that and the rainbow bracelet and the LGBT issues. So I think that's another thing we've been struggling with, in the same way that can we look at all the countries together and have one coherent conversation? The question is, can we look at all our three panels together and have one coherent conversation about how all the issues fit? Now, this is obviously a very big bite to take off. I'm expecting Scylla is going to help us make some progress during the final remarks. But this is our chance first to hear, in this sort of pulling back the camera, going meta, how do we put all this together and how do we move forward? So I'd first like to invite Mona and Mark to comment, and then just hear whatever other thoughts or questions other people have. So, Mona?
I was wondering whether to comment or not, or whether I have anything substantive to say over and above what Jay has said, because he's summarized it so well. I'm not sure I'm going to add anything on top of that. Thank you. The one thing I do want to kind of give a little bit of an opinion on is a larger conversation, which is what you're mentioning on strategy. I must admit that yes, there is a division between the academic discussion and the actual, the discourse on the ground. But doesn't mean that the academic discussion needs to stop. That's not what the point is. It just needs to be contextualized. It doesn't need to stop. It needs to happen. That is it's undeniable. And I think it's very interesting. And thank you, Jay, for bringing it up. I think it's very important that you go watch God Loves Uganda. I had the opportunity to watch a first screening when it was being created. Like, it was first screened in Kenya, so to a very target audience. And I think it's very important for you to watch that, because it really brings home what it actually means to not contextualize. Just to give you a little bit of a snippet, and I shouldn't do this, but I will. It's a spoiler, but forgive me for doing this. There's this part where this lady is talking to this other lady, missionary, is that what you call them? Missionary is talking to this lady who is, being attacked by houseflies, and, she has this baby who doesn't look like they've eaten in a century, and she's telling her, have you found God? I came from my apartment in New York having discovered God, and, the woman is looking at her like, A, I don't understand the language you're speaking, but 2, are you going to leave money, to feed my child? And just contextualizing the two issues, and it brings home how different Africa is. I think that was what I loved most about the movie. It was annoying, but it also brought home how different Africa is in relation to other countries, other continents. And then finally, just to kind of have, I unfortunately wasn't able to have this discussion just because this was not the context to have it, but we are having discussions around what you're talking about. However, we are having it in relation to strategy. We're thinking about, and Sibo mentioned it in her presentation, where we are looking at the problem of religious oppression. We are looking at the problem of getting rights for LGBTI persons, the same rights that everybody enjoys, but we are doing it through strategic incremental litigation, kind of building up, and that's why I'm happy Sibo went before me, because she mentioned how we're doing it, and Jay has kind of mentioned it in part, access to health, and that's how we're doing it. We're not going for the jugular. We're not going for constitutional reform. That's not what we're doing. However, we are doing something. It's not that we're not. So I think it's very important to kind of put that out there, because I think I really emphasized, the fact that we don't want to do something that is very contextual. So I think it's just something that while you're having your other conversations, we are doing something, but also it would be nice for you to, when you're having a discussion, if you ever have a discussion about how other strategies that we can adopt in Africa, contextualize it. So you're having these fantastic discussions about, religious exemptions. How about we just have discussions about how we can talk about what you're calling global liberalization, I think, and how we can bring it to Africa and have a contextual discussion. Let's have that academic discussion. Thank you.
Thanks. Mark, any comments?
Yeah, thanks in particular, Susan, for the invitation to sort of join you in pulling the camera back a little bit, because I think that's one of the huge benefits for activists and practitioners in participating in discourse of this nature. Firstly, I want to really agree with Jay that the process of progressive reforms that we've been talking about in different case studies absolutely is not linear. Proceeds in fits and starts. And the metaphor that I prefer in the Irish situation is one of paradigm shift. I think that's what we're seeing. I think that's what we're experiencing between two competing discourses, and I think it's manifesting itself in a variety of ways in the abortion debate, in the same-sex marriage debate. In other ways, I was talking at the coffee break to Lawrence about the possibility opening up for a progressive review of our current religious ethos exemption in statute. The trick is, I think, to recognise a moment of paradigm shift when you're living in it. They're clearly recognisable when you do your historical review. But I think we may be in such a moment in my country at the moment, so we're very keen to capitalise on that. Three things that I think, as human rights advocates, we could and should be doing more of, and that, if we're not careful, the being in the fray of battle with religious opposition can sometimes blind us to, because that is what it feels like when you're experiencing. Firstly, I think we need to make sure that we're not too or so distracted by the antics of our friends on the religious right that we forget that we actually do have real allies on the religious left, that there is a religious left with whom we may share a substantial value set. And I think that's something we're certainly guilty of and trying to work on more. Secondly, though, I think we need, when the moments arise, to be courageous in calling out people on the religious right when they misappropriate the language of rights. And it can be tempting to be drawn into what sounds like, now let's have a rights-based discussion with you. Maybe you're moving onto our territory. I don't think that's what it is at all. I think we should recognise it for what it is, which is a misappropriation, a new form of attempting to roll back progressive change, and we should call it out for what it is. We need to be clever in doing that. Maybe we need to be satirising people rather than calling them homophobes, even if we think that they actually are homophobes, but it's something we should be looking at. And then the third thing is, and another reason why I think we do need to be pulling the camera right back, is there are global forces at work here. We should be in absolutely no doubt about that. And one of the advantages that this new global network, the International Network of Civil Liberties Organization, gives us is amongst our 10 organisations the possibilities to do some more advanced mapping. Where is the money coming from that is going to fund work on what is colloquially called the Kill the Gays Bill, the aggravated homosexuality provisions in Uganda? Is it emanating from the same sources that is funding some of the campaigning work that we looked at in Ireland? I think that's something we need to be prepared to look at. It's scary, it's difficult, because a number of our organisations, of course, also receive foreign funding. But I think there's an absolutely fundamental difference, which is that we use it to promote values that are embedded in international human rights standards. If it's effectively being used to promote hate and bigotry and so on, and that's something that we should be prepared to take a closer look at. And it is one of those things that I think the global network, INCLO, has very much in its sights at the moment.
Thanks, Mark. Any other comments? General comments? Go ahead, Sibo.
Okay.
Could you use the microphone so that people in the back can hear? It also helps us to record.
Yeah. I think when you're saying nobody is saying equality now because everybody understands, I think that's a big mistake, because there are a lot of people that are saying right now. And that's why for many years most of us have been put on a back foot, because you have to defend while you are saying maybe this is the difficulty. So as a lawyer who is doing capacity strengthening for lawyers on strategic litigation on LGBT rights, the application that I get, the cases, most of them is about decriminalization, because people who have gone to law school and they come back, for them, that's the most obvious answer, that if this is the problem, that's not it. So you have the lawyers, you have the movements for themselves, they have gone, they have attended, and people are telling them there's Texas versus Lawrence and all sorts of things, why are you not doing it? So I've been to lots of meetings where you end up at the end of a meeting with a vote. We go now or we go after 3 years. And then there are funders who are funding this work. They are looking for somebody who's taking to court. Because if no one is having this conversation, this happened last year. Liga Bibo in Botswana was not only litigating free speech, but they'd merged decriminalization. This is what happened in the Malawian case. There was a constitutional reference to challenge the law. So what I am saying is this is a conversation that is coming from also. I'm not saying the ILGA map does not exist that says this is the green, this is the amber, this is the red. But what I am saying on the ground, this is what we are dealing with. So there is a conversation that says right now.
That's it? Okay, Robert, go ahead.
Okay, and then finally...
Oh, I'm sorry, you weren't. Yeah. I'm sorry.
The issues around traditional values and what's happening in at the UN and what Russia is trying to do, that also that needs to be contextualized. So, for example, under the African Charter framework, there is a section dealing with rights and there's also a section dealing with duties. And the duties have never been interpreted by the Commission or even the court on what it actually means to have the duties. And what activists are doing, working on this, is to say traditional values do not have a meaning, and if people have decided that this is what Russia does, because we understand it can be dangerous, it is dangerous in the UN, but we are not going to come here within this regional space and reject traditional values. So right now at this session, we are trying to get a resolution from the Commission that says we are embracing traditional values, because African traditional values are not homophobia. African traditional values do not mean that this is what you say they mean, to discriminate against other people. And I do think that that's part of how you begin to reframe and you reclaim the language for what it means. For other people, I can understand why it makes sense for institutions and individuals working in the global north, like we are not going to go into these traditional values because it's dragging us down. But if we have nothing to work from because the equality language is not acceptable to people, you say, this is what. So we're starting to talk about the stuff that has come out of the South African Constitutional Code about humanity, Ubuntu, and all sorts of things, all of these traditional value concepts that talks about all of these traditional values, that a value of hate, a value of persecution, we have not had, we don't know about this value. So, so that's what I was trying to respond to about them.
Sure. I'll just maybe say a brief thing on the second part. Just the first one, we can talk offline. And I wonder, because I think that the degree of American imperialism is so high that there are so many people who have so much more power, who are saying homosexuality is un-African and untraditional, that I think that would be a really interesting kind of conversation to think about the costs and benefits of, do we go inside the traditional values frame and do exactly what you just said and contest what we mean by traditional values, or do we hesitate to do that because there are so many well-funded, powerful sources who are trying to really own that, and traditional values are, a heterosexual family, procreation, children are traditional values, and so I'm just questioning that. I don't have like a disagreement, just a question.
Yeah. So I'm going to call on Robert, and then what I'd like to do, because we only have a few minutes left, is particularly invite Louise and Nelson, who organized all the substance of the conference. If you have any closing reflections, I'll give you, the privilege of taking those last few minutes if you like, and if not, we'll see if we have time for somebody other than Robert. Go ahead, Robert.
I'd just like to add to what Sibo, Mona, and Jay have said about the need for a nuanced and sensitive approach in Africa, Asia, and the Caribbean, rather than equality now. Because I think we need to remember that 30 years ago, when I was an associate at Milbank, and the issue was anti-discrimination law in New York City, no one would say this is going to lead inevitably to same-sex marriage, because that was inconceivable at the time. Now, the fact that it has been achieved in many places in the Americas, in Europe and South Africa, is great, but it is hugely complicating the work of activists in other countries. So it's a very difficult situation to be in, but the only solution I can see is to use a message of each country at its own pace, to try and reassure people that there is no inevitability. The inevitability that would scare people in Africa is South Africa. Decriminalization 1998, marriage 2006, 8 years. So here's my reassuring counter example. France, 1791, 2013, 222 years.
Louise or Nelson? Nelson, any comments? Not required. Louise, nothing there? Okay, does anybody else want to make one more comment? Or are we ready to go to closing remarks? Okay, well, let me say before turning over the floor to our closer here, that I think it's been an incredible conversation, and we in fact are capturing it in two different ways, one of which is the recording, so you actually can go back and watch it again or tell other people to watch it on the Brooklyn Law School website. We're also going to have the writings in the Brooklyn Journal of Law and Policy for those of you who are writing things, which will also be great. So we just raised at the end here a whole variety of questions, and I'm sure Scylla will inspire you to think about even more things. And this is not the end of the conversation. I regard this as not, okay, now we're done with that. I think we're formulating issues and framing things and just getting ideas from each other about how to think about all this. So I now want to turn the floor over to Priscilla Smith, who was the third organizer of the substance of the conference, as well as figuring out who to invite. Didn't they do a great job? So Scylla is Senior Fellow and Director of the Program for the Study of Reproductive Justice at the Information Society Project at Yale Law School. Before that, Scylla was an attorney for the Center for Reproductive Rights for 13 years, including serving as U.S. Legal Program Director for about 4 or 5 years, and she litigated 2 abortion cases in the Supreme Court, and she's 1-1 for those. She's published many places, including the best academic institutions at Yale, Harvard, and Brooklyn Law Review. So, Scylla, close it off for us.
Well, you've exaggerated my credentials a little bit, but you all don't need to know that. I'm going to, because I know this is the end, you all want to leave. You're all 1 foot out the door. I know you're tired, you're hungry. So I'm going to do just a few things. First, I am going to do thanks once more to a bunch of people. I'm going to talk about my priors, what I bring here. I'm going to tell you a story about birds. And then I'm going to leave you with a few thoughts about Miley Cyrus and Pope Francis. And the hope here is not to answer all the questions we have here, but to give you a few more things to think about as you go along. So first, I will give thanks in the religious tradition to our keynote speaker, who I don't think is here anymore.
He had to travel home.
Yes, he had to travel. Our wonderful panelists. Many of you have traveled from very far away, and we really appreciate it. You've traveled such long distances to share your knowledge and experience and insights with us over the last 2 days. Thank you, of course, to this wonderful institution, the Brooklyn Law School, for hosting, especially Dean Allard, Professors Susan Herman and Nelson Tebbe, the staff led by Liz Alper, the students, especially the Journal of Law and Policy, and all of you folks. Fabulous. Thank you so much.
May I just interrupt and add our fabulous IT people?
Yes, and I mean the IT people. Wonderful.
Lloyd,
you guys are
and
awesome.
Swan and Kirk and Alan. Thank you so much.
Yes, and especially David, who just went and got me a Diet Coke, which I often need for a little. So thank you guys so much. And I can't tell you how happy I am to be here in Brooklyn and not at another institution in New Haven in so many different ways. It's lovely. So thank you. Also, thank you to the Luce Foundation for their support, and to the many other funders who support our work, both anonymously and non-anonymously, and you all know who you are. Mostly, of course, I want to thank Louise Milling, who seized the moment for this conference and pulled this gathering off at a crucial moment in this debate with her inimitable mix of brilliance and great humor. She's a wonderful friend, and I thank her for that. And the ACLU generally, yay, Louise. She's very modest and humble pie, and we'll do all that. Anthony Romero, you're at my lovely institution, Yale Law School, the ISP, Jack Balkin, who had to go and talk about drones today. So we should all congratulate ourselves, pat ourselves on the back. Yay, great conference. This is a great beginning of a lot of wonderful things to come. So thank you. Okay. So, my priors. Let me just say, first of all, I'm a bit of a Jack Balkin acolyte, since hanging around with him so much. Today, I think I've become a bit of a Larry Sager acolyte, if he'll have me. I'm not sure. Oh, thank you. And let me talk about my priors and why I was excited about this conference. So, let's start with the religion part of it. Okay. My own views of constitutional interpretation were influenced by the fact that my father is an Episcopal priest. Okay, let me just put that on the table. There it is. And although the Episcopalians flirted with sort of free church in the 1960s, which was my favorite part of it, when we danced around a lot in big buildings and things, the Episcopalians are and reverted to their very high church and Catholic ways. Let's remember they are Catholics. They're not Roman Catholics or Pope-following Catholics over sex, remember, but they are very Catholic. And my father has written a book called, of all things, The Bush Still Burns, about God in everyday life. Yes, that's the real title of this book. I was born just 4 months after the start of Vatican II. That started in October of 1962. I was born in January of 1963. And one of the purposes, let's remember that, was to start a dialogue with the contemporary world. That was 1962. They were starting the dialogue. That dialogue ended soon after with the death of the Pope. Coincidence? I think perhaps not, but then I'm a bit of a conspiracy theorist. I grew up in a household with a bunch of anti-war activists, etc. Okay. My mother, on the other hand, now let's talk about conflicts at the heart of one's soul. My mother is so dismissive of religion and really any sort of philosophical thinking. She couldn't be bothered to tell you whether she was agnostic or atheist. Certainly one of the two, but what do they mean and what's the difference? Who knows? So that's sort of, I come from this place. Now let's talk about my priors on sexuality and equality, about sexual liberation in particular. About 25 years ago, it became clear through various ways that both of my parents were in fact gay, and in fact gender roles were always in question in my house in various ways, and women's liberation was a very important topic. Now this comes even closer to home in terms of my reproductive rights work, because as a campus chaplain in the 1960s, again my father, the Episcopal priest, was one of the campus clergy who organized the 1967 lecture of Dr. William Baird at Boston University, where he was arrested for distributing contraceptive foam to an unmarried woman. And that lecture then resulted in his arrest and conviction for violating the Massachusetts law that prevented distribution of contraceptive to single people, and later resulted in the decision Eisenstadt versus Baird. Now, I didn't know this until I had been doing reproductive rights work for about 12, 13 years, and my father was very, well, you know I organized that lecture. No, I didn't know that because I was 4 at the time, and you never told me. I'm supposed to just know these things and intuit these things, which is another thing about Episcopalians. You know and you intuit and you learn from the text. You're supposed to know this. I asked him once, Dad, do angels really exist? And he said, what do you think? I'm asking you. Okay, so that just gives you a sense of that. And now, the other thing about my dad and the sermons is that the only sermon I actually remember him giving, and I went to a lot of them when I was very little, then nothing for a long time, and then for 2 years when we were all at a boarding school, he was the chaplain of, I went to a bunch more. The only one I remember, not his fault, more my fault, is the one where he talked about Jesus' very famous statement that one should render unto Caesar the things that are Caesar's, and render unto God what is God's. Now, this is meant to teach us about the relationship between Christianity and secular authority. But, of course, like much in the Bible, and like many things my father used to say about angels, etc., as a man who lives more in the world of metaphor and myth than in reality, this statement about what is Caesar's and what is God's doesn't really answer anything, because we have to draw this line somewhere about what is Caesar and what is God's. And in that statement, Jesus took the coins and he showed them all. There were pictures of Romans on the coins, and the people who were asking him this question interpreted that to mean that they could in fact pay the taxes. The Jews could in fact pay taxes and it was okay. But he didn't really answer any question about where this line was between the Jewish religious authority and the secular authority of the Romans, right? Okay, now you're wondering, what does this have to do with anything? I think Larry knows. So let's go to a quick story about birds, red birds and blue birds in particular. And this is a story about the abuse of broad claims of religious authority, right? Now, this goes back to the Ferguson versus City of Charleston case, which is one of the cases I took to the Supreme Court. Louise is like, how is she going there? Okay, in that case, there was a nurse who implemented a policy of testing pregnant women for drug use during cocaine use, in particular, during pregnancy. And there was a nurse who we like to call in the briefs, we called her Nurse Brown, because it made her sound very like Nurse Ratched. So I was like, Nurse Brown, we'll call her throughout. And she used to write on the medical records of the white patients, she would write FOB black. And we were looking, what is this? Father of baby black. So then it became clear that of our 10 plaintiffs, 9 of whom were black and 1 of whom was white, that the one who was white had written on her chart FOB black, okay? And so this was used by us as evidence that there was race discrimination going on in this case, in conjunction with some other statements that she made about certain women being dogs in the street and other disgusting, horrible things that were going on. So this was raised. She said, she testified, they put her on, they cleared out the jury, they put her on the stand, and they had her explain this. And she testified as if in defense, and it was in defense, that, excuse my southern accent, which will come out when I say these words, my mommy and poppy taught me that there are red birds and there are blue birds, and that God did not intend them to mix. That is what she said. This was her religious view, and writing FOB black was her way of living her religious beliefs, and so you couldn't blame her for that. Okay, now this is 1996. It's not very long ago that she said this. The judge in that case said, do you think he thought that was relevant? Do you think he let this testimony go in front of the jury? What do you think? I want to see some heads.
Come on, professors. No, he did not. He said, I'm not going to let this go in front of the jury. And you know why? Because I play golf with people who think this way, and it's just the way they were raised. Okay, so there is no limit to what our conscience can lead us to believe. It was her sincere religious belief, and that's what the judge thought. The judge saw that as her sincere religious belief. We don't accept that now. In 1996, there was a judge in the District Court of South Carolina who still did, but we don't. Okay, now, that's sort of a sad and depressing story, and you're all very quiet. But let's have some positive thoughts that bring us back to today, riffing off of two recent flashpoints in the news involving Miley Cyrus and Pope Francis. Now, I was thinking I would have a sort of Sinead O'Connor moment, not rip up the Pope at all, but have a picture of the Pope, maybe with Miley sitting in his lap or something like that. But I thought, no, it could be profane, and I didn't want to offend anybody, so I wasn't going to do that. So I just talked about it instead. But the Miley Cyrus thing, for those of you who are from out of the country and maybe don't know, is she was danced at the, Louise has been in the dungeons and she doesn't know either. So Miley Cyrus is a pop singer who was a child star on Disney. She was very innocent, and Hannah Montana was her pseudo name, and she's very popular with the young girls and stuff. She's great. So she now is growing up. She's 20 years old. She's getting very sexual in her videos, and people are being very appalled by this. And at the VMI, the Video Music Awards, which is kind of like MTV Music Awards, she did a very lewd dance with a pop singer, and she was dressed in sort of scantily and very sexualized, and her tongue was out and all this stuff. There was a huge uproar about this, okay? And an incredible backlash from all sides, it seemed, both from some older feminists who, and this reminds me of the veiling debate, were saying, this is appalling. She's subjugating herself, and they see what she did as quite degrading, right? Other people just thought this sort of too sexual, too lewd, despite the fact that other dancers on stages everywhere are doing bumping and grinding, and nobody cares. But Miley Cyrus doing it was somehow crossed the line. Okay. So it's clearly about the creative power of women's sexuality and what happens when somebody owns it and uses it in this very powerful way on stage. It freaks everyone out. So I think, yes, we're winning the culture wars, but we haven't won them yet. They're not over. They're still sputtering on. And certainly the Supreme Court, which is going to hear some claims coming up this term, which are very scary, is very scared of women's sexuality when it's out of their control. And if we don't believe that, just look at Justice Scalia's latest interview where he talks about the devil with the red horns and the tail, and he knows it's out there, and he believes it, and I bet he sees it when Miley Cyrus is on the stage. Okay. Now let's go to Pope Francis. Now Pope Francis has revealed himself to be a living originalist, like Jack Balkin, who some of you may know that Jack has sort of coined this living originalism term to refer to the fact that living constitutionalists should pay more attention to the original principles in the Constitution when they're talking about how they see and how they view the text. That, in fact, also he identifies that and I think he's right. That's why I say I'm a Jack Balkin acolyte. That most of the constitutional interpretation that is done, whether in the name of living constitutionalism or in the name of originalism by Scalia, is some form of living originalism and starts with original principles and then is influenced by history and text and all the rest of it. I mean, history and evolving notions of culture, etc. So Pope Francis is talking a great deal in this interview he gave recently about taking into account the lived experience of humans, and recognizing that humanity learns and evolves. And he may, in fact, be restarting the Vatican II conversation. Interestingly, he said he's convening a group of 8 other people, probably men. Are they all men? Did he say men, or did he say? Yeah, we think they'll be men, which is interesting. He thinks 9 is an important number, which I think it's a little scary if he's modeling himself after our 9. But so he may in fact be starting this conversation, this Vatican II conversation with the world. The most important aspect of which, for our purposes, I think, is the idea that Susan Herman raised yesterday, which is the idea that people of conscience make decisions with their Holy Spirit, their God, their deity every day. And this is, I think, what Larry's talking about partly when you talk about the breadth of this idea and notion of conscience and how broad it can in fact be, right? So sometimes these decisions, and Pope Francis says this, that are made according to conscience include decisions about sex. These decisions about sex, who you have it with, whether you're going to have it, and what the consequences of it are, what they're going to be, whether you use birth control or not. He refers to the use of contraception, and in fact to whether or not you choose to have an abortion. These are decisions made by people, decisions of conscience, made with, as he refers to it, the Holy Spirit enters them, and they come to a conclusion and make a decision with the Holy Spirit. These are decisions to be respected by priests in their pastoral care. So these are conscientious decisions. These are valid exercises of religion, at least as valid as whether Hobby Lobby buys health insurance for its employees that includes birth control, or a decision to bake a cake for a gay wedding in your cake baking business. I'm going to say that again because it's hard for us to accept sometimes that having an abortion is a matter of conscience if you're a religious person. If you're not religious, it's not a matter, for me, it wouldn't be a matter of conscience. I'm not in a religious sense, because I am an atheist. Well, on some days. On my mother's days. But if you're living your life where you make decisions in consultation with your God, then making that decision is a religious decision, and it's a decision you're making because you think it's the best one, not just for you, but for whatever children you might already have, or for whatever children you might have in the future. And so we're left with, in some circumstances, these 2 competing decisions of conscience. And we return back to the Caesar-God question. What belongs where? So I don't think I haven't solved anything or answered the question. Seeing these things this way may in fact, I think, complicate our questioning of these issues and where we place things. But it places these decisions of conscience on equal footing. And when evaluating which decisions can't be discriminated against, let's make sure we include the decisions I would make as my decisions of religious conscience if I were religious. So, this is a tough one. Is refusing to fund abortions when you fund another woman's decision to give birth discrimination against an exercise of religion? Goose, gander. How do you like them apples? Right? Okay. The test for the Pope, I think, is will he talk about the role of women in the church more than to say Mary is the mother of the church? Will he say more than Mary is the virgin mother? Will he, in fact, admit that Mary had premarital sex? Probably with Joseph, I think, given how nice he was about it. But maybe he was just a very evolved man who was really in love with her. I know people like this. And that was a decision she made in conscience, and it had good consequences, because for whatever else anyone thinks of the man Jesus, whether you think he's the Son of God or you don't, we know he was a pretty good guy. He talked about the poor. He talked about the meek inheriting the earth. He hung around with prostitutes like Mary Magdalene and other oppressed peoples, and he cared about them and he helped them. He might have been a little crazy in some people's views, but so be it. So that's the test for the Pope, where how far will he go in thinking about the role of women and how far will he push the church. The test for the court is that when they decide what is a sincere religious belief, as Professor Geddix has outlined to us, will they see conscience ideas equally and subject them equally to universal demands for equality? And what is acceptable to them if the idea of conscience is viewed as broadly as Pope Francis thinks it should be? I suspect that if they viewed these things equally, the court's view of what a sincere religious belief that would be protected from secular values would shrink drastically. We would not see much outside a practice of faith that was actually the exercise of whatever the form of the actual practice of religion was, as opposed to the things you do, the actions you take in secular society that are made in accordance with your belief. So that's where I'll leave it today. I thank you all so much for this conference. I look forward to continuing this with some of you who I've already got scheduled to come to Yale, and others of you I hope I'll get you to come to Yale, and we'll continue to talk with Louise and carry this on and move forward with all your great work. Thank you.
So, thank you, Scilla. And before I wish you all farewell, I have one more important piece of logistical information, because there is no end to the thoughtfulness of Liz Alper. She was realizing that some of the panelists may be heading straight to the airport or going off to travel, so she has upstairs yogurt and fruit, just to make sure that you don't starve on your way. So thanks once again to everybody, to the Luce Foundation for helping to support us, for everyone involved. I thought this was an amazing conversation. I hope, as everyone says, that we continue it in many ways, and safe home.